Good morning. Good morning. It is Wednesday. It's February 12th, 2025. Lots in the law happening today and a few surprises about the Law Nerd Shop. So don't worry, we'll get there too. Replay crew, love you. Everything will be timestamped down below. For those of you that reminded us that timestamps weren't working on a last video, we have been working on it. Sometimes they just don't populate right, and that is okay. So today, we are going to go to court for a short hearing for Donna Adelson, but that's not all. We also are going to be covering the latest order, and we have been waiting months for the court to do something in the TikTok psychic case. If you've forgotten, like, WTF is happening in that case, don't worry, you're not alone. We'll do a road so far. But Donna Adelson has also made a number of motions. The court has set a tentative trial date for June. For June? What does that mean? That means that we are going to have Karen Reed overlapping Corey Richins and then Corey Richins overlapping potentially Donna Adelson. We're trial. We're just going to be in trial. So it looks like Donna Adelson may start in June. We're going to figure out how to deal with overlapping cases, but March, we might also have Keefe D in Nevada. So let's go. For those of you asking, and I saw a number of you asking, Kohberger starts in August. Yay. So I love live trial. Sometimes too much of a good thing is just a lot. So we're going to be potentially in trial. We're just all of y'all. We're just in it. Law nerds, let's ride. Like, we're just trialing. So we're going to go through today 2 of the motions. I'm going to overview them. We're going to do really truly an overview of the motions Donna Adelson is making for bail bond. And we're going to talk about that. She is now in solitary. She had been attacked in custody. We're going to hear about that today in the hearing. We'll talk about it in the motions, and a motion to suppress the jail call. If you've not heard the jail call we're going to be talking about, I did a podcast episode about it ages and ages and ages ago. We'll link that down below if you want to go catch up on that. We'll talk about it. I don't know if we'll have time today to go over that jail call, but the vibes of the jail call are in the motion, and it's actually a pretty interesting question. So we're going to talk about that motion to suppress. Do I think it's going to get suppressed? Well, we're going to talk about the motion. We're going to talk about the motion. Is the throat still sore? Yes. Yes, it is. But we're going to figure out all these trials. We're going to do it. And I see a lot of questions about the Law Nerd Shop. We're going to talk about that real quick. And then we're going to go to court. So for all of you that are like, how you feeling? We're just icky. I'm just icky. I am not completely just flat, but I am also not 100% well. So we're just going to do the things. Don't worry. It'll be nice to pop and look at some other cases because we've had so much going on in just a few cases. And then members, I will be polling to see what you guys want to cover tomorrow. We're going to let you guys choose tomorrow's show. So let's roll the intro. Then we need to talk about the shop a little bit to avoid any confusion. And then we are going to roll. So law nerds, let's roll the intro and let's get to court.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not Let's get into it.
I see those of you saying you miss food court. We're gonna bring in a music court, which will be a bit like food court. I think that's the vibe I'm going for. So for all of our Law Nerd Lounge members, they get first access to our pre-sale. All of our YouTube members, our Law Nerd members, get access to our pre-sale tomorrow for the Law Nerd Shop 2.0, launch 2.0. But we have taken a note from our past orders to make sure that everything goes out in a timely fashion and that our pre-sales actually go out when they are pre-sold. We had a little bit of a break of our system last time because, well, the law nerds live to break stuff. So we are staggering our pre-sale to make sure that nothing breaks. We are not going to be at risk during pre-sale of things selling out. We did the best that we could to make sure that things would be available for you. Everyone who is not a member, not in the lounge, we are going on sale on Valentine's Day. It is a law nerd, love type of a launch. So Valentine's Day, we will be launching. You will get all the information. The shop will be open. There will not be a password, and you will get to shop the launch. So we will be doing all of the stuff. Abby, we have worked on Cart Logic to help with shipping to the UK, but we do ship out of the US because our goods are made in the US and shipping rates keep changing. The way I know more about international shipping rates than I ever thought I needed to, when we shifted over to goods that were sourced and made in the US, we ship out of the US. We used to have some drop shipping elsewhere. In the future, we are working on also having a warehouse in the UK, but it is going to delay the amount of time between launches because we need to quality control stuff, then ship it back, then sell it. But we are working on it. So we have Cart Logic set up. We only charge the exact shipping rate that we are charged. We have the best shipping deals that we can because we have partnered with a large warehouse and we get their bulk shipping discounts. They are still not always great depending on where we are shipping to. It's just difficult, but we are looking at warehousing and having a warehouse in Europe to try to alleviate some of those issues. One of the problems we have, and we'll talk about this maybe on a members only live, is that it might require slightly different variants, and then it would really break us into two different shops. So if we had two different shops, we would have an international shop and a US shop, and that is also something that we are considering because the goods might be slightly different. We want to make sure the quality is the same because we don't want law nerds to have different experiences. And trying to figure out how to have different experiences is not necessarily something we want to do. We're very mindful that we want all the law nerds to have access to what they want to access, but also keeping in mind the challenges of shipping from the US. We do use the same distribution that a lot of musicians use. So that is why we end up with those bulk shipping rates because our warehouse ships so many different things. But we are considering shifting to also having a warehouse in the UK, but it might change the goods. And if we do that, we will let you know and keep you in the loop with that. But we want the law nerds to have the same experience. So that is where our challenges are with having a US based store and potentially branching out to an international based store. So we are trying to figure that out. It is not easy at all because we don't want to just send you guys goods that are different just because you're our international crew. We don't want to limit our sales to just the US if law nerds want it. We are mindful that shipping is challenging from the US. So we are working on all the different ways that we can mitigate that and make sure that you receive the same quality goods. So it is something we talk about very frequently. So we might end up with an international shop and a US shop. We'll keep you posted. But just so you know, it is something that A, we are very mindful of, B, we talk about quite frequently, and C, we are trying to solve to keep the experience the same, but also try to figure out shipping, tariffs, import, export, and all the things. So that's what we are working on. Law nerds, trust, the team Baker spends so much time working on making sure we have the best experience, and it is not always easy. So that's what we're trying to do. It is a challenge. And then I know a lot of the Canadian law nerds from the last launch, because of the postal strike, are just getting their merch now. So that is where we're at. Kathy B, the members do get the password tomorrow for the members on YouTube. The Law Nerd Lounge is part of the app, which gets a first access. So the password for YouTube is tomorrow morning. The password for the Law Nerd Lounge in the app is for today. Those are different memberships. So that is what we are doing. But we need to roll into TikTok Psychic so we can get to court for Donna Adelson. That hearing was yesterday. I don't think it was streamed anywhere, but we found one channel that shared the video of that. So we're going to go to court a little bit later in the day. But we want to make sure that we cover TikTok Psychic because so many of you yesterday were like, wait, what happened? What happened? Brianna, the Tumblr is not in this launch, but if you reach out to us, I think we have a very few Tumblrs that we can make sure to assist you with. So Brianna Rangel, email us, Miguelina, or one of the mods will at you. One of our mods, Julie, will at you and give you the email address to reach out, and our team will look for your name and we will take care of that Tumblr. So, Claire, the passwords will be available for the YouTube members tomorrow. You will get a message breaking it all down how to access it unless you are in the Lawnerd Lounge. So if you are in the Lawnerd Lounge, then you will see it in the Lawnerd Lounge. And if you are in the lounge, you know where it is. All right. Let us talk TikTok Psychic, shall we? So the Tumblrs, I see some of you still looking for the Tumblrs. I will talk to the team and ask how many we have left and see if we can put a post up in the YouTube space after this launch. We will try to do that. So please don't use the UK for the EU. That makes things as complicated as getting from the US. Line, that's completely fair. I think our last one was not technically in the UK. It was in the EU. And that's where our old warehouse was. So yes, no worries. But I see a number of you asking about the Tumblrs. So I will talk to the team about a solution for that because I think we do have some. And we will see if we can put those somewhere after this launch and make sure that we can get those to you guys if a few of you still want them because we had taken them off the shop. So let's talk TikTok. Let's talk TikTok Psychic. For those of you that don't remember this case, I'm going to do the best that I can to do a brief summary because Lord, oh Lord, so much has happened. And the way I just said brief, did you guys watch Traitors this week? Did I roll the intro? I don't remember. We did. Did you guys watch Traitors last week? I think Tom Sandoval sounded like he had just had dental work and could not move his upper lip. And so when I just stumbled over my words, I felt like I sounded like Tom Sandoval trying to talk last week on Traitors, sounding like he just came out of dental work. And I like rewound it and I was like, Dr. B, like either he sounds like he just had anesthesia. Like what is happening? And he's like, so many people are looking at Plus and Rob. And I'm like, what the hell is happening? I was like, what is happening? What is happening? It was wild, but he sounded like he had just come out of dental work and his lips were numb. It was wild. All right, y'all. Let us get to, I saw one question about shipping times. Alexis, they are listed on the site, the shipping times, and we are working on getting everything shipped out. It's going to depend on where it's shipping to, but we are working on getting everything shipped out within a few days of orders. The pre-orders should be shipped out before the end of the weekend. All right. Traitors doesn't drop till Thursday. Yeah, last week's episode. I don't know what day it is. Wednesday? Something like that. We need to do a summary of TikTok Psychic. And then if I see more questions about the shop, I'll circle back when we get to the end of today's episode. Do not worry, Lawners. It's all going to be good. I'm excited. You're excited. Let's talk TikTok Psychic. For those of you that are like, Emily, what case are we talking about? Welcome. We have not covered this case in a few minutes. This is a civil defamation case going on in federal court in Idaho. There was a TikTok creator who said in over 100 different TikToks that a professor at the University of Idaho was responsible for the murders of the 4 students that Brian Koberger is being prosecuted for. The creator was sent multiple cease and desists, internet gonna internet, and the creator did what creators do with cease and desists. I mean, not all creators. Some creators look at the cease and desist and go, danger, danger. And some go, you're not going to do anything for real, and then use it as content. So the creator interneted, and we are now in an ongoing federal civil defamation suit. The creator is representing herself, pro se, through a series of litigation, and this federal court allowed for call-in attendance. So I attended the hearings that have been had, and I recounted those to you. At one point, I was never so glad I was on mute. I used to do court call back in the day when I was doing legal consulting, and I would do court call for attorneys that needed somebody to make appearances or what have you, and after I left the DA's office. And I have never been so glad I was on mute, because the judge asked a pretty normal question for a defamation case, and the psychic creator responded, I didn't see that coming. The way I almost died on the other end of the phone. I was like, maybe you should have. So we get through the early processes. The TikTok creator tries to countersue. All of that gets yeeted. So much gets yeeted. At one point, the attorney for the professor called this something like a clout circus. Yep. And just went in that this creator was making these sensationalized videos accusing someone of murder for essentially clicks and views. The TikTok psychic was trying to double down on truth as a defense. And the court was like, okay, but do you have like evidence, like an objectively reasonable basis of evidence? And so the TikTok psychic said to the court, you are discounting and discriminating against me and my spiritual beliefs because you are not counting my spiritual guides and my tarot cards and my beliefs as objective evidence. And the court said, we need objective evidence. That's how court works. I'm not discriminating against you, not discriminating against your religion. I am not discriminating against your guides, who should probably tell you that this is a bad idea. But you need objective evidence to show that this is true. When that did not come forward, the court granted a motion for summary judgment, which ends the liability portion of the case. So defamation has been found. Liability has been found. The court ruled that there is no defense and that defamation has occurred. So now we're only dealing with the issue of damages. How bad is it? And there may be a trial based on damages only. So the TikTok psychic gets to the end of all of this and says, I don't want this judge. I don't want this judge. I don't want this judge. So the TikTok psychic, by the way, had already consented to the jurisdiction of this judge. It got sent to another judge months and months and months down the line. The other judge said, no, you don't get to just say, I don't like this ruling, I want a new ref. That's not how this works. This judge is not biased against you because they asked for objective evidence, not your subjective belief. Not how that works. So this judge stays. After that ruling was made, this judge ruled on the pleadings on the TikTok psychic's motion. And I want to make sure I get it right. The motion was named, because pro se, the motion was named the defendant's motion to alter or amend judgment. So the pro se defendant said, Your Honor, I don't like your call. I want a new ref. Like I'm taking my guides and going home. And the court said, yeah, you can't do that. And then the judge decided to rule on this motion to amend. Like I am imagining, because I paused. Every time I see a motion in this case, I wait for y'all, because there's no way to not do this together. So when I saw this order, I said, oh, no, we're doing this with the law nerds. What I imagine is happening is that the judge is going to again walk through their reasoning and say there is no reason to amend or modify the judgment of finding liability. You defamed the professor. You defamed the professor. Also, when I talk about the fact that there are some cases that I have strong feelings about, this is one of those cases. I have a tremendous amount of empathy and sympathy for the University of Idaho professor. Someone on TikTok went to the website and was like, you know what? There's fanfic here. This person did this person created that, and went on a blast across the internet, dragging this university professor into what was already a devastating quadruple homicide for their community, and heightened the fervor against this professor. Her university stood behind her, but she was accused of having an inappropriate relationship, inappropriate because it's with a student, an inappropriate relationship with a student, and then out of jealousy hired people to murder 4 students from the university where she is a professor. And when she said, please cease and desist, this isn't true, the TikToker doubled, tripled, and quadrupled down. And there's no undoing it. The shit's out of the horse. The articles are on Google. If she ever wants to find another job, this is going to have to be discussed. And she did nothing but have a job. And so this is not a public figure. She had a job at a university. It's bullshit. And it pisses me off because this university professor has had to spend quite a ton of money to undo somebody going after them for clicks and views and upending their life, because then everybody starts digging into it. And I think where I get particularly frustrated with this is that after working so long in the criminal justice system, you're very well connected to the fact that these are people with their own lives and dealing with their own grief. The entire communities in Moscow, nearby, in Washington and nearby, were grieving. I think other college communities were probably also shocked and stunned. So not only is the community upended and in grief, but then to be specifically targeted and harassed because you had a job is unacceptable to me. And it's not just news reporting. It's not based on leads. It is rank speculation and harassment. And at some point there have to be boundaries to that harassment. And people can't just put things on the internet and go, oh, nothing's going to happen. It harasses people, not only causing significant mental health impacts, but impacts at your work. Not all jobs have the fortitude to stand behind their employees when they start getting flooded with death threats. It's awful. And we've seen it in case after case, and it concerns me deeply that people who are amazing experts, like Dr. Curry, will choose not to do work in high-profile cases because of the level of harassment it opens them up to. And that worries me for the justice people will or won't get because they can't get the right expert for a case, because that expert may not want to deal with the fallout of doing their job. It's frustrating. So this is a case I have very, very strong feelings about and have since the beginning. And I truly think that the TikToker knew and made choices because the writings have been very linear and clear. It is a misunderstanding of the law. The TikToker is like, I believe it, therefore it's true. And that's not how that works. But there were lots and lots of time that the TikToker could have, pushed the stop button and stopped and chose to continue. And it made all of it worse. And for that, there are consequences. So you have speech, but sometimes that speech has consequences. So before we get into the judge's 16-page order. As we are talking about the internet and the dangers of the internet, I am going to bring in our sponsor for today because it is a service I have worked with, that I have recommended to friends, that I have recommended to others that work on the internet, and that has been incredibly important to me in my journey. And I am incredibly thankful to have them as a sponsor. So not only can I share their service with you, but also share a discount. So thank you to today's sponsor, Incogni. A huge thank you to today's sponsor, Incogni. Look, in conversations I have, not just IRL with those in my life, but with my friends online, with other content creators, one of the things we often find ourselves talking about is what happens when people try to go real world. But unfortunately, it is something that happens and is happening more and more. You never know how much of your information might be out there. And if you're where I am in life, it's not just my information I'm worried about. It's also my kids and my parents. What I love is that Incogni also has a friends and family plan, so I can work on making sure that not only are their addresses, phone numbers, email addresses, and other sensitive information removed off the internet. And you know that I pick sponsors that I trust, that I've worked with in the past, and that make it easy. With Incogni, you sign up on their secure site, you put in the information that you want to have removed, and then they will come back and tell you how much time you've saved and how many removal requests they've made, how many are in progress, and how many have been completed. So if you're ready, you get an exclusive 60% off with our code EmilyDBaker at incogni.com. 60% off an annual plan when you use code EmilyDBaker at incogni.com/EmilyDBaker. And you can hit the link in the chat or down below and start having your personal information taken off the internet. And it also gets rid of those annoying robocalls. So it's a plus plus. All right, let's get back to today's stream. And when I say I use it for my kids and my parents, yes, people have tried to find my parents, my friends from high school, where my children go to school, my husband, and that's stuff that didn't happen when I was at the DA's office. That is stuff that has happened since I started working online. When I was at the DA's office, we did have police protection on my house on a few occasions. We did take security measures because my husband had a physical office location, and that at times was a concern. I never had people try to find where my kids went to school, and I was working, putting people in prison. But you talk about somebody's lawsuit on the internet and shit gets wild. It is the way that people feel brave behind a keyboard is a whole different thing. And I think people forget that there are humans involved, that the people on the other side of a screen are still people. And that's one of the things that really, really frustrates me about this case is that when when people go real world, most people don't know how to protect themselves in a digital age. I think we are going to continue to see laws changing regarding digital harassment. One of the challenges to that is in the US, there are such strong protections as there should be for the First Amendment. But where are the boundaries of harassment? And where are the boundaries of making people unsafe using that speech? And the laws are still catching up. And that is difficult. So services like Incogni help. I don't talk about it a lot because it's something I deal with and move on. And it's never coming from this community. This community is like, we listen, and if we don't like what we're watching, we move on, because that's what, like, change the channel. And a lot of us grew up in a time where it's like, I don't want to watch this show. Change the channel. That's what we do. It's like, oh, that's not for me. Okay, I'll move on because it's not for me. But many don't seem to be able to be like, oh, that's not for me, I'll just move on. They want to just destroy it. And that's wild to me. I think we need content creators with all different voices and perspectives. I learned so much about how people live their lives, experience the world from different content creators. But if everyone gets harassed off the internet, we're only going to be left with the really abusive narcissists. Those are the only ones who are going to be left making content. And that's not what we want either. It's gotten wild. And I think we don't want a world where the people we want to hear from opt out because of the harassment they might receive. I don't want that in any of our public spaces. I don't want that for our elected officials, that they get, good people look at, running for office. I feel this way with my friend, Judge Abby. Look at going through the electoral process and are like, I have a good job. People don't know where my house is. Do I want to put myself at risk to bring some good into the world? I know I could do good. I know that I can improve things. I know that my voice is needed. But is it worth the personal risk to me? And a lot of people don't want to make that choice or opt out and are like, I'm good. I'm good. So it's wild. So for all of you, let's get to this motion. This case definitely strikes a chord with me, and I feel strongly about it. And I think that there are boundaries, and I think there need to be boundaries. It's okay to disagree with people. It's not okay to try to go to their house. That's not okay. It's not all right. All right. Let's talk about this order. If I take this off of the screen, it's because there are times that the pro se defendant puts her personal details on here and I take them off. This is an order from the court, so I don't think we will see that. But if I take this off screen, that's why. Let me swoop and go from there. And no, I saw a couple of you asking if any harassment had to do with this case. No, it did not. No, it did not. Also, when there are specific cases or when I know the source of where that is coming from, I do not specifically call it out. I'm going to take a Kendrick approach to a lot of that. It's noted and it will come back around. But no, I don't call it out because people want to know that it's working. I don't call it out. It's noted and we sit on it. I am a behind the scenes kind of girl. It's noted. I'm not dragging my community into bullshit on the internet. None of you need it. And I hate it. And I will not say this person's doing this or this is coming from here. Y'all don't need that. I will tell you, if people are getting spicy in the comments, do they feel better? Just let them go. If they're trolling in the live chat, we just boot them. But our community does not need to be manipulated into fights on the internet. All of our thoughts and time are way more valuable than fighting with people on the internet who enjoy it. Rob says this all the time. Rob says a variety of, you just end up wrestling in shit with a pig and only the pig enjoys it. So I'm not dragging my community in there with all of it. We just wait. Cause y'all, I rather you spend your energy here and we can be petty. Look, karma comes back around. It always does. So, but y'all don't, that's not your fight. And I hate it when people do that to their communities. When people drag their communities into internet beef, I hate it. It is not my vibe because I don't want to be dragged in if it's not my beef. Look, if it's my water polo team and we're all clearing the benches to fight, then, that's one thing. But I was also 20 and my shoulders didn't hurt. I'm old. We want to read our books, take care of our families, take care of each other and ourselves, and have some fun. That's all. And we want to know the tea that's going on in the law. So let's see what judge. This is not judge. Let's see what the judge has to say, shall we? This is Rebecca Schofield, who I call Professor, versus Defendant, who I call TikToker. I firmly believe that there are some that we just need to not raise in infamy. Like, infamy can be a powerful thing. And I don't need people who are wild and out to become infamous. So that is why I refer to the TikToker as a TikToker, because it's the platform they created on. Is that meant as disrespect? No, it's meant to not bring infamy on someone's name. Because if attention is what they want, attention is what we will deny. And here's how I see it with other things going on the internet these days as well. For those of you who have raised kids, been around kids, had little siblings, there are times when the tantrums and the feelings are big, 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 big. And if you match that energy, everything just explodes. Sometimes you just have to ignore the big feelings. Sometimes on the internet, people are playing at the big feelings because they just want to bait you into that type of engagement. But sometimes you just have to walk away from the big feelings. So when I see people having tantrums, we just walk away. So this is how I see a lot of this. We're just like, ooh, you're having big feelings. Y'all. There was a very drunk individual having very big feelings at one of the concerts I was at over the past weekend. And I actually said, because I was tired, I actually said, ooh, you're having really big feelings. It didn't help. It didn't help. It's on the level of you need to calm down when somebody's already mad. But you're having really big feelings right now. I see that you're mad. That sucks. Can we just turn back around and concert? Yeah. Maybe no more vodka sodas for you. Big, big feelings. But saying it to somebody's face can make them mad when they're having big, big feelings. So there are the big feelings. There are the big feelings. All right. It's like we don't use our hands. Can we use our words? Maybe we need some quiet time. Big, big feelings. Yes, I think a lot would be well served by therapy, but I can only control me. And then I can talk about it with my therapist. I can only control how I act. Emily said, oof, you're so angry. Yep. Kate, this is my new line. You're in your feelings more than Drake. Who's apparently big, big mad. This is a vicious rumor on the internet. Big, big mad at Duo the Owl. If you haven't followed my Insta stories, I've got you up to date on what's going on with Duolingo. All right. Did we skip our nap? Defendant's motion to alter or amend the judgment. You can't alter the judgment. Pending before the court is defendant's motion to alter or amend the judgment, docket 77. We're on docket number 89. Docket 77 was filed like mid 2024. Did your brain just go to 2014? Fuck. Ugh. Mid 2024. We are in 2025. This case arises out of the tragic murder of 4 University of Idaho students. I'm going to grab a couple comments that I love. We'll talk about Duo the Owl more. Just it's going to have to wait till questions because I want to get through everything. And I'm saving that one. All right. This case arises out of the tragic murder of 4 University of Idaho students in November 2022. Plaintiff, Rebecca Schofield, is a professor at the University of Idaho. She alleges that despite never meeting any of the students or being involved with their murders in any way, defendant posted numerous TikTok and later YouTube videos falsely claiming plaintiff, 1, had an extramarital same-sex romantic affair with one of the victims, which again, that victim was a student. She was a professor. Professor-student relationships are inappropriate and against the university guidelines. It can be defamation per se to call someone out in their profession in that way. So when you hear me referring to it that way or as inappropriate, it's because of the student-teacher dynamic. That's why. And then 2, order the 4 murders to prevent the affair from coming to light. Plaintiff sent cease and desist letters to the defendant in the following days and weeks. When defendant did not stop, plaintiff initiated this action. Plaintiff asserts 2 defamation claims against defendant. 1 is premised on the false statements regarding plaintiff's involvement with the murders. 1 is premised on the false statements regarding plaintiff's romantic relationship with one of the murdered students. Also, the victim's family doesn't need any of this. Like, the victim's family doesn't need any of this. There is already so much pain in a community when things like this happen that doubling down on that pain is intolerable. On June 6, 2024, the court granted, God, it was June? Oh. On June 6, 2024, the court granted plaintiffs' amended motion for partial summary judgment on the issue of liability for plaintiffs' 2 defamation claims. That means TikToker, as a matter of fact and law, defamed professor and has been found liable for such. The court concluded that the totality of the evidence reveals that there is no genuine dispute as to any material fact. You said what you said. What you said is not true. What you said is not true, and what you said is defamation per se. Period. No genuine dispute as to any material fact that defendant defamed plaintiff. When we get into the motions for summary judgment in like the Lively Baldoni cases, it's going to be wild. There were times working for judges before I went to the DA's office that summary judgment motions would come in bankers' boxes. Summary judgment is not a motion to dismiss. Summary judgment, the court evaluates the evidence to see if there is a genuine dispute. And sometimes it really narrows down what goes before a jury. But that means you get everything. Exhibits on exhibits on exhibits. I would have boxes of motions for summary judgment. But if you can cut out a couple causes of action or find liability on a few points, it narrows down what the jury needs to decide. If there's no genuine dispute, the jury doesn't need to decide it. Summary judgment is incredibly interesting. Very different standard than motion to dismiss. It's determinative and definitive and fascinating. I hated them, but I also loved them because like the judge basically is the jury in those motions, and it's fascinating. Just fascinating. So summary judgment, liability was determined. Damages can't be determined. On June 6th, for those of you asking, here it is. Also on June 6th, the court granted plaintiff's motion for leave to amend complaint to add punitive damages. So for those of you that asked, are there punitive damages here? There weren't. And the plaintiff proved that the creator's statements and behavior was so egregious that the court said, yes, punitive damages are appropriate here. In permitting a claim for punitive damages, the court concluded that plaintiffs established a reasonable likelihood of proving by clear and convincing evidence, which is a lower standard, that defendant's conduct in accusing plaintiff of an affair with a student before ordering that student and 3 other students' murders was oppressive, fraudulent, malicious, and or outrageous. That's the language that the court has to find. Fraudulent, malicious, outrageous, oppressive. To the extent, erect the mic. No, Emily. To the extent of plaintiff's damages, if any, or the extent of plaintiff's damages, if any, remains an issue for trial. That's an appropriate use of if any. Because this is defamation per se, the plaintiff did not have to prove damages. Defamation per se says the shit you said was so bad that it damages someone's reputation. You don't have to show me how. It damages someone's reputation. In other cases, if you don't have defamation per se, you have to show the damage before you get over that hurdle. Here, the damages are a matter of how much. Now, via the pending motion, defendant moves for reconsideration, alteration, or amendment of the court's June 6 MDO pursuant to Rule 59E. Specifically, defendant argues that 1, the ruling was based upon a manifest error of law or fact. Wrong. 2, should be amended to prevent manifest injustice and an impediment to justice due to the lack of judicial impartiality. The reason the court is putting in the quotes is because this is what the pro se defendant said. Due to a lack of judicial impartiality. And 3, erroneously allows for excessive damages. Don't make hundreds of TikToks. This case is a fuck around, find out for me. It's all fun and games when you're fucking around. Well, for at least one person. It's not fun and games when you're finding out. And what sucks for the professor is that in all realistic scenarios, even when they are granted damages, they are not going to get nearly any of it. And they are going to have to litigate to then get the damages. We talked about the Cardi B case 3 years ago. They're still trying to get to the beginning of getting damages in that case. And that trial was over like 3 years ago. It's a whole separate litigation to get damages. And it's something when people look at, well, why don't they just sue? It's because even if you sue and win, you could be stuck in separate litigation over damages for years. The very real possibility of civil litigation is that even when you win, you've lost so much money that you lose. And you're never going to recoup it. It is a very big barrier to civil litigation. It's like, you should just sue. It's like, well, yeah. Plaintiff opposes the motion in its entirety while also preliminarily arguing that it is procedurally improper. The arguments are considered below. Legal standard. The Federal Rules of Civil Procedure allow parties to move for reconsideration of court orders. Where a judgment has been issued, a motion for reconsideration may be brought pursuant to Rule 59E. In all other situations, the court has discretion to reconsider its decisions under Rule 54B, which permits the revision of interlocutory orders at any time before the entry of judgment, adjudicating all the claims and all the parties' rights and liabilities. In addition, district court possesses the inherent common law authority to rescind or modify any interlocutory order, so long as the court retains jurisdiction over the matter. Motions for reconsideration, however, are only appropriate in rare circumstances. The major grounds that justify reconsideration involve an intervening change of controlling law, the availability of new evidence, or the need to correct clear error to prevent manifest injustice. And that is what the TikToker was leaning into. Clear error. Nancy Forbes asked a great question in the chat and said, can they put a lien on property? Only if there's property to put a lien on. And in this case, it seems that there is an apartment, a leased vehicle, and no tangible property. They can try to put a lien. It seems that the creator is no longer on the Clock app. They can try to lien like a YouTube channel if that channel's monetized. However, the creator can turn off monetization. It would be very interesting to see what would happen if you put a lien on a YouTube channel and then a creator was just like, I'll turn off monetization then. So it will be hard. Garnishing wages and stuff like that is also hard. Motion for reconsideration is not an opportunity to rehash issues already addressed. Somebody tell Carrie Morrissey. Somebody tell Carrie Morrissey that a motion for reconsideration is not an opportunity to rehash issues already addressed. I'm going to start saying this to my kids. I'm sorry, you're asking me to reconsider, but this is not an opportunity to rehash issues already addressed. That's going to happen. It doesn't happen often now because we kind of logic our way through things, but the, hey, I really would love to play another couple rounds of Valorant with my friends. I know it's 11 and I have a chemistry test tomorrow. This is not an opportunity to rehash issues already addressed. Don't make me turn off the Wi-Fi. Emily, are you that parent? Only if I need to be, but have I turned off the internet for the entire house? I only needed to do it twice. Only needed to do it twice. Those games are long, man. I'm in the middle of a round. An hour later, what are you doing? Still in the middle of a round. Fuck, what? Oh, So, not an opportunity to rehash issues already addressed or advance arguments that could have been raised earlier. It's not a do-over. In other words, a motion for reconsideration should do more than simply restate the position that was unsuccessfully advanced by the party relating to the initial motion. You had your shot. You shot your shot. You threw away your shot. Whether or not to grant reconsideration is committed to the sound discretion of the court. The judge gets to decide. Discussion. Defendant's motion does not raise an intervening change of controlling law. Ooh, I ran out of air. Controlling law that would affect the court's MDO, nor does it raise new material facts or evidence that happened after the court's order. If something new happens, that's different. Tamara said, my son, this game doesn't pause, Mom. I hear it all the time. I hear it all the time. This game doesn't pause. And then apparently, maybe I'm being lied to, but apparently, I've never actually sorted out if this was true. If they leave the game in the middle of the game, there's like a penalty for when you can join the new game. Oh, yep. Defendant's motion does not raise an intervening change of controlling law or facts that happened after the court's order. The court finds that defendant's motion rests upon the assertion of either clear error or manifest injustice. To that apparent end, the judge is like, I mean, I guess this is what you're saying. Let me endeavor to make your arguments for you. This judge has been very, very, very patient. But I told you guys at the beginning of this case that the judge being patient is because the hammer was going to drop later. And there were moments that I was just as frustrated as y'all were. Because it's like, sanctions! We cannot let this stand! Your Honor, what? I was frustrated too. And I said, the judge is being incredibly patient because when the hammer drops, it's going to be final. And the judge was patient and gave opportunity after opportunity after opportunity. And then the hammer fucking dropped. Like, dropped. And liability was determined without a trial. There was no more opportunity to fuck around. The court was so patient. And I said, this is what they're doing, but I was so annoyed by it too. I want that instant gratification, not the long game. The judge was playing the long game, and judges do that all the time. Little win, little win, little win, little patient, little consideration, boom, when it matters. The court goes to that apparent end. I've endeavored to guess at what you're saying. Defendant raises the following specific arguments. That the judge's order violates the First Amendment. Your Honor, I can say what I want. I can say what I want. Emily, you're sick. Do not try to Cartman. I'll say what I want. The court does not have jurisdiction relating to the murder. This is ma'am, this is a Wendy's. This is a defamation case. The court doesn't need to have jurisdiction over the murder. The TikToker's argument here was that because no one's been convicted and the court does not have jurisdiction over the murder, if I start saying murder like Alan Cumming, it's not my fault. It's that I am obsessed with Traitors and my brain can't stop hearing him go, murder. So, but this is not the time for the brain to default into that level. This is serious, Emily. The court does not have jurisdiction relating to the murders. She was literally arguing that until someone's convicted, it could be the professor. You don't know. You're not in charge of that case. That was the argument. Plaintiff does not have a valid defamation claim. False. Plaintiff is not entitled to judgment as a matter of law. False. The court lacks subject matter jurisdiction. False. The order contains false statements of fact. False. The court was not impartial. False. Granting punitive damage violates Idaho law. False. Plaintiff's complaint is barred by absolute and qualified privilege. Ah, the TikTok privilege. But I said it on social media, so it's fine. False. Plaintiff's complaint is barred by absolute and qualified privileges. Tarot card and oracle card reading messages are not false statements of fact. Ma'am. However, the court accurately recites those arguments. Those are the arguments. As explained below, the court is satisfied that its order was not the result of clear error and did not result in manifest injustice. You want to know what's manifest injustice in this case? The fact that somebody had to bring this case to get someone on the internet to stop accusing them of committing murder. That. As explained below, the court is satisfied, I am repeating myself, that this order was not the result of clear error and did not result in manifest injustice. The court considered the material facts presented by the parties in reaching its decision. Instead, defendant's motion ultimately asked the court to rethink. Oh God, I forgot that was in there. It was like, you better reconsider what you did. There was like a vaguely threatening argument in there. Like, you should really rethink this, Your Honor. It was wild. To rethink what the court, it had already thought through, rightly or wrongly. I remember that. This is not the proper purpose of a motion for reconsideration. Defendant's motion is therefore denied. Defendant's motion is not precluded as procedurally improper. The court first confronts plaintiff's argument that the motion is procedurally improper. Because the court has not yet entered final judgment, the court said it is not procedurally improper and it does not preclude the motion. So we're going to zoom past that to get to the rulings on the orders or the arguments from the defendant. So not procedurally improper. The order did not violate the First Amendment. Defendant claims that the First Amendment protects actions derived from spiritual beliefs. Quote, and this is quoting from the motion, defendant cannot be punished for believing in a spiritual practice, its messages, nor can she be punished for acting on that belief. You can believe what you would like to believe. You can practice generally how you would like to practice. But you can be punished for acting on that belief depending on what the action is. If the action violates the law or civil torts, then yes, you can be punished. You are not above the law because you said, well, they said it was fine. Your Honor, the guides are good with it. I don't think they are. The guides are good with it, so we're good. To the chat saying, tell that to Lori Daybell. Right. There are lots of people who've done some really fucked up shit in the name of their beliefs. Ma'am, I would like to talk to you about Kool-Aid. Emily, keep going. Keep going or we're never going to get out of here. There are things you cannot do. She in turn argues that when the court concluded in its order that she defamed plaintiff, the court singled out her spiritual practice, took a stance on the truth or falsity of her spiritual belief and practice. You can believe and practice what you want. You can't accuse people of murder. There are boundaries. Goes on to say that the court's order prevented her from freely exercising her spiritual practice in the future. Again, you can read your cards. You can't accuse people of murder. To be clear, the court takes no position on defendant's spiritual beliefs. But where those beliefs manifest in, the court's much more elegant than I am. Where those beliefs manifest in unlawful action, the court is not relegated to bystander status simply because the unlawful action might have a spiritual beginning. Is much more elegant than I am. What the court said. I adopt that as my official position. Such is the case here. Independent of defendant's spiritual beliefs, the court concluded that defendant defamed plaintiff when she publicly accused her of having an inappropriate same-sex romantic affair with a student and then engineering that student's murder along with 3 other students to cover up the relationship because those accusations had no basis in fact. Facts. Addressing the shifting burdens at play on summary judgment, the court relatedly concluded that defendant's spiritual beliefs, without more, were incapable of creating an issue of fact relative to these statements' falsity. These conclusions neither singled out defendant's spiritual beliefs nor served as critical commentary. I'll provide the critical commentary on defendant's spiritual beliefs. But I guess I'm also providing commentary on the actions, not the beliefs. They were instead the product of the court's application, the ruling, the product of the court's application of the law to the facts consistent with the federal rules of civil procedure. Law, shit you did, result. This is law. This is the shit you did. This is the result. Moreover, the court already addressed a similar argument when resolving defendant's motion to set aside the court's August 8th memorandum decision and order. We've already done this twice now. There, defendant argued that because the court, quote, does not have subject matter jurisdiction over the plausibility of spiritual practices, which was a new one for me. Your Honor, you do not have subject matter jurisdiction over spirituality. It was a new argument. The court, she also argued that the court initially erred in denouncing tarot readings and defendant's spiritual connection as a spiritual practice for the purpose of overstepping the separation of church and state as required by federal laws in the First Amendment. Oh, she also, this was one of the motions where she argued that she was omniscient. Quote, here, defendant's claims were supported only by her spiritual intuition. But intuition, even if summoned by one's spirituality, does not make a legal claim plausible. Otherwise, there would be no standard against which such claims could be tested under Rule 12b-6. And asserted First Amendment protections would automatically insinuate affirmative claims from dismissal. This is not, or insulate, sorry, affirmative claims from dismissal. This is not the standard, nor can it be. You can't just say, I believe it, it's true. At bottom, which is a turn of phrase I'm not a huge fan of, at bottom, claims must be based in fact, not conclusory and unverified beliefs. That is a great phrase. Absent objectively verifiable factual allegations, defendant's claims were implausible. Nothing more, nothing less. This same rationale applies now. The court's order did not turn on plaintiff's beliefs, just the absence of factual support. Facts, the absence of facts. Thus, there's no First Amendment violation. The court does not lack subject matter jurisdiction. Defendant claims the court lacks subject matter jurisdiction for two reasons. One, the court cannot use a civil tribunal process to decide if plaintiff is innocent or guilty of murder. That's not the question. And correspondingly does not have the authority to rule Mr. Koberger guilty of murder. Two, plaintiff does not have damages over $75,000 to confer diversity jurisdiction. Interesting arguments. First, says the court, this is a civil, not a criminal action. Now, I love that the court's like, let's just reset for a minute. This is a civil, not a criminal action. The court properly considered the elements of plaintiff's civil defamation claims against defendant, and in doing so, resolved those issues in plaintiff's favor on summary judgment. Though the court's consideration of those issues may have touched upon a matter of criminal concern in a parallel criminal proceeding in state court, the court never endeavored to apply the elements of the crime of murder and adjudicate plaintiff innocent or Koberger guilty. Accordingly, the court did not exceed its subject matter jurisdiction. We're not even getting into the damages amount because it is properly alleged. We're not going through the law on that. It's properly alleged. Let's see. The damages is left for trial. The amount of damages is left for trial, but it's reasonable that it's over $75,000 with punitive damages. How much would you give this professor? If you were sitting on a trial and you heard all these facts that you have heard in this case, how much would you give the professor of punitive damages? Those are the punishment ones. Those are the find out damages. Those are not the, oh, you missed 4 days of work and you would have been paid this amount. Those are the fuck around damages. Is it over 75,000? All of you were like, yep. Just all. A lot of you said all. Millions. Those punitive damages are meant to say your behavior is egregious. It is outside the boundaries of our society, and we do not accept it. No. All of you look like you're over $75,000. Lori, I doubt she can collect, right? More money than can be paid. And I don't know. I would need to look at what the max is for punitives. The court properly resolved plaintiff's defamation claims. Defendant variously complains that the plaintiff did not have a defamation claim, that the plaintiff is not entitled to a judgment as a matter of law, and that the order has false statements of fact, and that tarot card and oracle card readings are not false statements of fact. Well, the card might not be false, but your interpretation of it and then saying it on the internet is the thing. Distilled down, defendant essentially contends that the court committed clear error of manifest injustice by finding her liable for defamation because plaintiff has not satisfied her burden of proving defamation claims. Defendant fundamentally misunderstands this entire case. That is the point of this entire case. At the outset, defendant's arguments in these respects reflect a disagreement with the order. She believes, the court is so patient in this parsing, she believes she did not defame plaintiff because the statements about her are true. But disagreement, no matter how vehement or impassioned, does not warrant reconsideration. And just because you don't like it doesn't mean it's wrong. There's lots of things we don't like that are still accurate. While defendant's motion can be denied for this reason alone, her particular arguments do not show clear error or manifest injustice in any event. The court's like, but let me tell you why. I could go period, but let me tell you why. Regarding plaintiff's defamation claims, the court adopted the parties' recitation of the elements under Idaho law. This is actually one area where the creator had a very nuanced argument, and the court spent a lot of time parsing the argument of what proper elements applied and whether or not it was public figure. It was actually a really nuanced and interesting legal argument. Ultimately, the court ruled against her, but it showed that some of the misunderstanding, to me, I interpret the misunderstanding as willful and deliberate misunderstanding to put a foot down and say no. because there were other areas where there was very clear understanding when she thought it would help her. Regarding plaintiff's defamation claims, the court adopted the parties' recitations. The court only consulted Idaho jury instruction 4.82 to inform the issue of who, plaintiff or defendant, has the burden of proving the falsity or truth of the element of plaintiff's defamation claims, what defendant now complains about. It was a really interesting argument. But the defendant was the creator was trying to push the court to say, okay, I said it's true. She has to prove it's not true. And she didn't prove that she didn't commit the murder. So she has to prove that she didn't do it. It's not that I have to prove that there's a factual basis for what I said. She has to prove that there's not a factual basis for what I said. So she was trying to shift the burden back on the plaintiff and was arguing that truth as a defense means you can just say truth and then the other side goes. And that's not how the law breaks down. It's like Michael Scott being like, bankruptcy. It's not how that works. Without resolving the burden issue once and for all, the court concluded that even if, and the court went arguendo, even if it was plaintiff's burden to prove falsity, she satisfied the burden by demonstrating that she had nothing to do with any of the students or their murders. After citing evidence stating this is powerful evidence at the summary judgment stage, it not only substantiates plaintiff's arguments that defendant's statements about her are false, it also highlights the complete lack of any corroborating support for defendant's statements. In this way, plaintiff has sufficiently demonstrated the absence of a genuine issue of material fact regarding the falsity of defendant's statements about her. Under Rule 56, this shifted the burden to defendant to dispute the claim by setting forth facts showing that there is a genuine issue for trial relating to whether her statements about plaintiff are true. In relying only on her spiritual investigation, the court concluded defendant did not satisfy her burden. That's not enough. That's not enough. The court articulated the undisputed legal standards applicable to defamation claims and properly applied the law to the record as was necessary to decide the plaintiff's motion for summary judgment. Footnote 2 sets out the law and the arguments. We went through this order already, so I'm not going to rehash the order anymore. Defendant's related argument that the order contains false statements of fact is similarly unpersuasive. For instance, she disputes the court's contention that she posted over 100 sensational TikTok videos. But Your Honor, they weren't all sensational. Some of them were mid. Emily. Too much? No, not on this case, it's not. In her counterclaim, defendant stated that she posted over 100 TikTok videos of her finding. You said it. These are defendant's statements. Defendant also said plaintiff was informed about defendant's social media accounts. Plaintiff knew. Defendant likewise challenges the court's claim that defendant does not dispute that she communicated statements about plaintiff to others or that these statements, if false, are defamatory. I was on the hearing when the court was pressing her on this, and the court said, if it's not true, is it defamatory? And she said, yes, but it's true. She's a murderer. The TikToker also argued to the court that the court shouldn't take the statements of the plaintiff as true, and dead ass, this was her argument. Your Honor cannot take the word of a murderer. This was in court. Cannot take the word of a murderer. So what the professor says cannot be considered true. What? I think that's when the court was like, and we're done here. In her briefing of the motion, defendant acknowledges that her statements about plaintiff either impugn plaintiff's honesty, integrity, virtue, or reputation or expose plaintiff to public hatred, contempt, or ridicule. That is the definition of defamation. Nevertheless, if the court were to exercise these statements from its consideration, that would not change the outcome. The order did not depend on these points, but rather on defendants' repeated and undisputed statements about how plaintiff ordered the killing of 4 individuals to cover up a relationship with one of the murdered students. Finally, there is no merit. Ooh, the court got a little sassy. Finally, there is no merit to defendant's claim that her statements about plaintiff were based on her spiritual beliefs and thus incapable of representing false statements as fact. Defendant, Traitor, holds herself out as someone who solves high-profile, unsolved murders. Hand in hand with that claim, she has publicly stated shocking things about plaintiff, repeatedly insisting that those statements are absolutely true. To her followers, more than 100,000, according to plaintiff, those are not statements of fact. Or no, those are statements of fact, not just spiritual beliefs and opinions. She held it out as fact. I've solved this. I have the answers, and the answer is this. Defendant's representations and pleadings throughout the course of litigation prove this point. Defendant pleading via an affirmative defense, plaintiff planned, ordered, and executed the murders. Since the accusations in TikTok videos are substantially true, there is no claim for defamation. She did not say, that's my opinion. She did not say, I can see a world where a professor at the university did these things. She said, this professor with this name from this website, this face, this department did this thing because of this. And then she doubled down on it and said, my defense is it's true because it's true. In short, defendant supplies no basis to conclude that the court committed clear error or manifest injustice. The court has not violated defendant's right to a fair tribunal. Defendant asserts that, quote, from the onset of complaint, the court robbed her of her right to an impartial tribunal. This court was so fair, it was fucking annoying. To be perfectly candid. This court went above and beyond to accommodate a pro se defendant. This defendant got away with shit lawyers would never get away with. As proof of the undersigned, the court's lack of impartiality and inherent bias regarding her spiritual practices, defendant points to instances in the record where the court ruled against her. The court can rule against you and not be biased against you. You're just legally wrong. There doesn't have to be bias for that. The internet's so broken on there's bias. You're just wrong, bro. It's just the law. Also, lawyers are real good at getting into lawyer brain and parsing out the differences. Lawyers represent clients all the time that they don't like, that they don't care for, whose calls they don't want to take, and they still do their job. It's their job.
Bruh.
And everybody's like, it's such an internet argument. Your Honor, you're biased. Shut up. It's not bias. You're defaming people. People use the word bias so much they've lost an understanding. Not y'all. Y'all are fabulous. Lost an understanding. Lost an complete understanding of what that word even means. I'm starting to sound like Judge Cannoni. Exhausted. exhausted. Because this judge was so above and beyond patient. It's just annoying. Hey, TikToker. No, nobody's going to cell block 1 on this case. It's just a civil case. So she points to instances where the court ruled against her. Ruling against you doesn't mean you're biased. Footnote 3. Though, as the plaintiff underscores, defendant did not reference the multiple occasions leading up to this point where the court ruled against plaintiff and for defendant. The court let this defendant off the hook multiple times. The court could have let the initial default judgment stand and be like, too sad, too bad, so sad. And the court was like, no, this case will be heard on its merits. I'm not going to knock this case out on a technicality, and we're going to let it be heard to the cost of plaintiff, the monetary cost of plaintiff. There was a default judgment at the beginning of this because the defendant didn't respond. The court could have just let that stand. But no, 3 years later, this case is still being litigated on the merits. Defendant's myopic focus Defendant's myopic focus on the court's most recent ruling ignores the broader record that shows that the court has been more than fair to defendant. Facts. I love that the court cited the plaintiff just to make note of the defendant's myopic focus. Just hilarity. Hilarity. The court is citing the plaintiff to say, I said what I said. The court has already addressed an identical argument following the dismissal of the counterclaims, stating, the court's like, per my last email, quote, the court's analysis and defendant's disagreement relating thereto do not support a finding of bias or partiality. Just because you don't agree doesn't mean someone is biased. Let's see. And then it goes on to cite case law on that. And the court says, in sum, defendant's disagreement with the court's adverse rulings may represent a bias or a basis for appeal. Now my brain's doing it. May represent a basis for appeal. They do not, however, justify voiding the rulings or establish any bias whatsoever. Defendant's motion to set aside is denied in this respect. The same rationale applies now. The past judge, remember, she tried to yeet this judge, so another judge had to review this and say, nah, we're not doing that. The district judge, Brailsford, recently agreed when addressing defendants' similar claims of the undersigned's bias in a motion for reassignment to a district judge. Quote, the record does, and I read that that was months ago when that came out. The record does not show the magistrate judge was biased in any manner towards defendant. Instead, the timing of defendant's motion to withdraw her consent indicates defendant's real motive is to avoid the judge's ruling. Ding, 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 ding. Defendant's only recourse to challenge these rulings, however, is an appeal following final judgment. Thus, defendant has not been denied an impartial tribunal. Allowing a claim for punitive damages is not against Idaho law. Fuck around. Meet, find out. Just because you disagree with it doesn't mean it violates the law. Defendant either misunderstands the order on this point or simply disagrees with it. Either way, there is no clear error or manifest injustice. Denied. Addressing the requirement that a punitive damage award requires both a bad act and a bad state of mind, the court concluded that 1, defendant's defamatory statement about plaintiff represent the foundational set of bad acts. You said the shit you said. 2, the absence of any objective basis for those statements. You pulled the shit out of thin air. Even when confronted with contrary evidence, represents the foundational bad state of mind. You said what you said and you didn't give a fuck. These conclusions, while indirectly touching on defendant's spiritual beliefs, were not a repudiation of those beliefs as defendant appears to be arguing. It's a repudiation of the shit that you said. Simply put, defendant knew or should have known that the statements she made about plaintiff had no basis in fact, and thus were false. That she continued making those statements in crass and provocative ways. Ooh, Your Honor. Your Honor. That's some federal judge strong language right there. Some strong words from a federal court. The judge has thoughts too. The judge watched the TikToks, is what the judge did. This is the federal court in Idaho. That she continued making those statements in crass and provocative ways, despite objective evidence to the contrary, supports a claim for punitive damages under the Idaho law. That is the find out. Defendant's defamatory statements are not privileged. The court is sitting here going, why do we even have to make this argument? Defendant argues that plaintiff's complaint should be barred because her statements are privileged. The court has rejected this argument when it denied the motion to dismiss. Defendant's TikTok videos were never made in any proceeding that can be understood as judicial in nature. Oh, and then she argued that she told the FBI about her findings. And so the statements were made to assist law enforcement. And the court said statements made to law enforcement are not going to be taken as defamatory, but you put that shit on TikTok. You didn't just call the tip line. Calling the tip line, if you're wrong, is not defamation. You are calling a tip line to give them information and then they sort through it. But you didn't just call a tip line, did you? Mm-hmm. 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 Honey 2800, I think in this case, this whole ruling is just tower for this defendant. Defendant's TikTok videos were never made in a proceeding that can be understood as judicial in nature and therefore not absolutely privileged. And while statements made to law enforcement may be subject to a qualified privilege, defendant's TikTok videos existed independently of any criminal investigation into the murder of the 4 University of Idaho students. That is, the alleged defamatory statements embedded within defendant's TikTok videos were not relayed just to law enforcement as part of a discrete criminal investigation into the murders. Instead, they were effectively disseminated worldwide. She wanted to be Mr. Worldwide. Her email address had her name is God in the email. So there's some grandiosity going on there. The statements may have also been communicated to law enforcement, but that does not immunize them. Right. But Your Honor, I told, therefore it's privileged. You also told TikTok. Order. Oh, the statements aren't privileged. We knew. Based on the foregoing, it's ordered that defendant's motion to alter the amended judgment is denied. GFO. GFO. Just GFO. The end. This is still going. This is going to go to trial. I have not considered sitting my ass in a courtroom outside of the Jen Shaw case. It is deeply uncomfortable. But Idaho is beautiful. And a trial on the damages in this case might only be a couple of days long. So when this goes to trial on damages, I'll keep you posted. If we can make the timing work, I'll go watch. I will go watch because the trial on damages should only take a day or two. So we'll see. It's not set. There is no trial set on this yet, but it will go to trial on damages because there is no way it's going to settle on the question of damages. It's just not. There's no way this can settle. And I feel for the professor in this, but this will go to trial on damages. 2-3 days at most. I mean, the jury's going to be told this is defamatory. And then they're going to hear what the TikToker did and probably see some of the TikTok videos. And then the professor is going to testify and say, this is what happened to me in my life. This is the mental impact, like we saw Cardi B testify to in the Cardi B defamation case. This is the mental and emotional impact this has taken. This is the career impact, if any, that it's taken. This is the harassment I received. This is the harassment my family received. That is all of what will come up at the damages trial. And then I imagine the TikToker will testify and say, but she's a murderer. Don't listen to her. And the jury's going to go, nah, nope, done, just done. That's not set yet. So in summary, before we switch to Donna Adelson, let's do a quick summary of this because the court was like, no, what we're not doing today. Yet again, the TikTok psychic has tried to get the court to change its mind because she doesn't like their ruling. And the court has yet again said that is not a sufficient basis to change my ruling. For all of you who are like, why has this case not just been thrown out of court yet? Because the plaintiff deserves to have their day in court. The plaintiff professor brought this suit. Punitive damages are on the table. This case has been decided as to liability and is going to go forward to a trial on the damages if it can't settle. I don't see this settling on the issue of damages. So just a few days ago, the court ruled for the last time that the summary judgment motion being granted will not be undone. The judge has reminded the TikTok psychic that spiritual beliefs are not the problem here. Making unfounded factual statements accusing someone of crimes are in fact the problem here. And for that, this case will go forward as to damages and punitive damages only. So I'm interested to see where we go next. I think there will probably be a case management conference set and then a date set for the damage trial or the trial on the damages. And the jury will be told that defamation has already been proven because that was ruled on as a matter of summary judgment. And this case is 3 years in. We are 3 years into litigation because a professor's picture was picked out of a website and then it was blasted to the whole world that she is behind the University of Idaho murders that Brian Koberger will be standing trial for later this summer. So I feel for the professor in this. It is very difficult to undo that type of damage. And Google's not going to take all those articles down talking about this. It's something that will follow her for the rest of her life. And I don't think there's any amount of money to make up for the way that something like that can change your life. Because she was living her life and then got thrust into the spotlight and harassed because of it. And there's no amount of money that regains that feeling of safety. For any of you who have suffered harassment, crime, you know that feeling of safety, like you can mark that moment and you've got the before and then the after, and you can mark how you've changed, how your view of the world has changed, how you orient yourself to the world. And I feel for the professor in that very much because none of this needed to happen. It's reckless. It's atrocious. It's irresponsible. And for what? You don't just get to ruin people's lives with impunity. And many wouldn't have the financial resources to try to make it right. And I'm glad the professor has sought to make it right because it's important to keep these conversations going in courts and to look at what the laws look like regarding digital harassment, because the laws are fairly well set with physical harassment, with harassing phone calls, but the laws are still changing with regard to the online space, things like swatting, doxing, and digital harassment. So we will continue to see these conversations happen. I think they're important to have these conversations, which is why I'm still covering this case. This one, we're going to the end. We're in it till the end, y'all. However many years it takes, we're in it. Let's talk about Donna Adelson, shall we? Because it's time. It's time. It's time. Let us get to Donna Adelson. Oh, we've got court, we've got motions. I think we're going to do motions first. I think we're going to do motions first. But chat, you're right. For all of you that made a motion to fly to Florida, you are correct. Y'all, we got to go to Tallahassee. So I know some of you probably don't feel like flying right now. Don't worry. You can take a spiritual flight to Florida. You can just astral projection. For those of you that would like to visualize yourself there, you can visualize yourself in Tallahassee. For those of you that can't visualize, I'm just going to talk you through it. We're going to go to Tallahassee. Drink of choice, snack of choice, comfy chair, low lighting. I know. It's going to be great. We're going to have a neuro-spicy friendly airlines. No loud noises. No heavy scents. Noise canceling headphones for everybody. Low lights. It's going to be great. Let's go to Florida, y'all. You ready? Let's go. I know, from Idaho to Florida, all of you in the chat that live in Idaho, you can share with us what the temperature is. But those of you that are in Florida are like, it's in the 80s right now and sunny. Thank you for the weather report. We're going to be landing now in Tallahassee, where the weather is a lovely 80 degrees. It's sunny. Enjoy a day at the beach. Don't forget to hydrate, and don't forget your sunscreen, because we all need it. I don't care what age you are. We all need the sunscreen. It's definitely not 80 and sunny in Middle Tennessee. I'll tell you what. All right, I'm going to do a brief summary of this, because in these motions, we're also going to get a summary. Oh, boy. Okay. How do we do a brief summary of this case? Because it's not brief. Donna Adelson is the last. No, wrong word. Donna Adelson is the latest in a line of defendants that have been charged and the others convicted with the murder of Dan Markel. Dan Markel was Donna Adelson's daughter's ex-husband, the father of her grandchildren, her former son-in-law. Donna and her son Charlie, brother-in-law to the victim, were alleged to be part of a murder-for-hire conspiracy plot. There was a middleman who was a woman, but I will call them the middle person. There was a middle person and then two gunmen. The gunman and the middle person have been convicted. That is all done. Charlie Adelson was tried, almost 2 years ago now, and convicted. Donna Adelson, right after Charlie's conviction, was stopped at Miami International with a one-way ticket. Wonder what she was doing. That is the topic of conversation for today. She was getting ready for trial in September. And the day of trial, everybody's in their trial suits, hair's ready for the first day of jury selection. Everybody's ready to go. Trial is ready to roll. And there's a conflict with the defense attorneys, because the defense attorneys representing Donna also represented Charlie. And he did not waive his rights to that conflict. And it was a shit show. And all of you, when this case started and Donna had the same lawyers as Charlie, all of you said, how is that not a conflict? And I said, well, the court would have had to have waived the conflict. Charlie said he never waived the conflict. It was represented to the court that he waived the conflict, but Charlie was going to be a defendant, not a defendant. Charlie as a defendant. Charlie's been convicted and sentenced. Charlie was going to be a witness for the state. Who would cross-examine him then? His former lawyers? That's not going to work. And he didn't waive it. Charlie has been arguing those issues on appeal. We'll get back to that another day. So Donna was pissed that the lawyers she wanted are no longer her lawyers. And then the judge said, okay, the lawyers who were Charlie's lawyers need to go. And then about a month later, the judge said, you know what? The more I thought about this, all the lawyers on the team need to go. Everybody's tainted. Everybody out. We need new lawyers. And that's where we're at now. We are pending trial on the conspiracy to commit murder and murder for Donna regarding the victim, Dan Markel. And we are now with the new lawyers, and the new lawyers are making motions to the court as we are moving towards what looks like a June trial date. I like this judge. He's pretty funny. He's very even. But when the judge is frustrated, you can tell, but he doesn't even break being even. The judge's energy is very much, I am so disappointed, I can't even be mad. Like, I am so disappointed in you. Like, your soul should shrivel up and fall out your feet. But the judge did charge the delay to the defense, and they had to pay for the delay to the state. Because as the state's bringing witnesses in, they're bringing witnesses in from prison, and prisoners can be housed in different states. That's not uncommon. So you're transporting people in from all over the place and ready for trial. You also have a full jury veneer sitting there cooling their heels. So we're going to go to court today after we do the motions. So let's motion and then court. Does that work? Does that work? I hope that works for everybody. Works for me. Works for you. Let's go through these motions. Donna's mad. Donna wants to not be in custody. Donna strikes me as someone who doesn't get told no very often. Donna seems like she is used to getting her way with her family. Donna seems to feel that maybe what works for everybody else is just not for her. And for those of you that aren't remembering this case, she's the one that laundered money by washing it. And the middleman said that the money was actually wet when she was paid in stacks of money. Would I be shocked if somewhere Donna Adelson was also Googling luxury prisons for rich people? Nope. No, I wouldn't. No, I wouldn't. Donna's interesting woman. Yeah. Yeah. Entitled is a mild, but the money laundering sends me, because it tells me that maybe you're not appreciating the situation correctly. It's, I don't know, it's giving Office Space. Donna is definitely having big feelings about being in custody. I will say there are things I am I don't know if empathy or sympathy is the right word. I understand Donna's concerns with being in custody. I understand that for a 75-year-old woman, that this is a rude awakening, and that her physical safety is compromised by being in custody. That happens to many. And when you look at all of this, I really think that when we get to the end of this trial, Donna is going to be kind of at the tip of the spear with her son, Charlie. And because there have already been, 4 trials on this? 5 trials, because one was a retrial. There's a lot of evidence out there about what Donna was up to. Here's the thing. If your child or yourself is going through a difficult divorce. I don't give legal advice on this channel often. Murder's not the answer. Murder's not the answer. Divorces are hard. Divorces can be messy. If you're going into a marriage or a relationship or a domestic situation, clear communication, prenuptial agreement. Nothing says love like a prenup. Why? Because it means you respect each other enough to have a conversation about what happens if things don't go wrong or don't go well. It is a sign of respect. And if somebody stomps their feet and says, but if you really loved me, we wouldn't have this conversation, maybe it's time to reconsider. Because clear communication is a sign of respect. And talking about what happens if a marriage does not work out at the beginning when things are good is the same as negotiating an employment contract. If I need to leave, what happens? It's like signing up for a gym. Are you going to hold me hostage if I want to leave? I had a gym once when I needed a spinal fusion, would not pause my gym contract. I lost my fucking mind. I was like, I can't come to the gym. I need to have a spinal fusion. So while I'd love to be at fucking yoga, what I can't do is yoga. My back doesn't work at the moment. Gym contracts are the worst. They're changing. Have a conversation going into something, how you're going to get out of it. Work relationship, mutual respect. Mutual respect. And if you don't want to do a prenup, that is fine. You can live with someone. You can decide how you want to divide up assets or property. Do not mutually own a property together. Tom and Ariana. Have these conversations. That's all. That's all. All right. Let's talk about why murder's not the answer a little bit more. I'm done ranting. There are way too many family law cases where this happens. Family law is one of the most dangerous areas of law for lawyers to practice, more so than criminal defense attorneys. Yes, that's true. Oftentimes, criminal defense attorneys, their clients respect that they're doing their job, and their clients are like, we all got to do a thing. And if you respect me as a person, I respect you as a person, and we're all in this game together. Family law, the emotions are so large that it is incredibly dangerous. And it is needed. But the attorneys who have to navigate the big feelings in family law, I'm sure Rob talks about this on his channel more than some. It is hard. It is not easy. It is not what I wanted to do. I didn't want to be a mediator. I didn't want to be a therapist. This was not my calling. I wanted to be a teacher. And my dad's like, you don't have the patience for that shit. So law, and now basically teacher. I love it. It all comes full circle. Let's talk about Donna. Donna would like to not be in prison. She's not enjoying that experience. This is a no for her. I am going to note that we are going to talk about assaults. So just know that Donna says she is being extorted and says she has been attacked in custody. That does happen. That is not an uncommon experience. So that we're going to talk about that. Let's talk about Bruno. Donna. This was filed February 7th. Today is February 12th. We're going to go to the hearing February 11th in a minute. This is not, why don't you want to play nicely with me today? Hold on. No. It's just, maybe now? What about now? We're not going to go through all of the legal arguments just because I want to make sure we can, there we go. I want to make sure we can get through the hearing as well. Defendant's motion to set bond and schedule an Arthur hearing. Let's talk about it. Defendant Donna Adelson, by and through counsel, would like to get the fuck out of custody. That's a summary. Procedural history. This will be helpful. Excuse me. Excuse me. The water is just not watering, apparently. June B said, Donna says 10 out of 10 do not recommend. Yeah, that's definitely Donna. Donna doesn't even want to be in Tallahassee. She has a lot of attitude about Tallahassee. She's like, send me back to Miami. Ew. I don't want to be in Tallahassee. She has total attitude about it. Adelson was arrested November 13th, 2023. We watched her arrest video and she was just like, what do you mean you're arresting me? Ma'am, we listened to your jail calls. You knew they were on to you. Donna was arrested November 13th, 2023, and on November 15th, 2023, she was indicted for first-degree murder, conspiracy to commit first-degree murder, solicitation to commit first-degree murder. These murder-for-hire schemes, people really think if they didn't pull the trigger, they're going to be fine. No. Aiding and abetting, conspiracy, and solicitation are a thing. Solicitation's a separate crime. They're going to find you, man. Your phone's going to tell on you. And you know what's going to happen when the person who pulled the trigger gets arrested? They're going to say, I don't even know this dude. I just got some money. There's no loyalty there. Don't you think you're not going to get thrown under the bus for a plea deal? It's the first fucking thing that's going to happen. The bond amount was listed on each warrant for these charges, indicated FAR for first appearance required. At the first appearance, Adelson was denied bond on count 1, and bond was set in the amount of $25,000 on counts 2 and 3. So no bond on the murder. On or about December 5th, 2023, the original counsel for Adelson filed an emergency motion to enjoin the jail for an independent psychological evaluation or release to house arrest based on the alleged violations of Adelson's Sixth Amendment right to counsel. A hearing was held on the motion December 11th, 2023. The court found that there was no violations and entered an order denying the relief sought. On January 8th, 2024, a motion for substitute counsel was filed, which was granted January 9th. The attorney that became counsel for Adelson was withdrawn from the case due to conflict. On the eve of trial, September 17th, 2023. So the attorney substituted in and then got yeeted out at 9 months later. From a review of the records, it does not appear the issue of bond was ever addressed by new counsel. Due to the conflict of interest, Adelson's pretrial confinement in the Leon County Jail was extended for approximately 9 months to await a new trial date. The state of Florida has not filed a motion for pretrial detention. Well, bond was denied. Well, very good. The trial in this case is scheduled to begin with jury selection June 3rd. General statement of facts. On July 18, 2014, Dan Markel was killed while sitting in his car in the garage of his Tallahassee home. Professor Markel was a prominent law professor at the Florida State University College of Law. Tallahassee police began an extensive investigation, which involved who?
The FBI!
Yep. And law enforcement officers in multiple jurisdictions. On July 17, 2015, remember this is from 2014. We're now a year later in 2015. TPD released new details in the investigation. On May 25th, 2016, Sigfredo Garcia was arrested in the case. On or about June 28th, 2016, Luis Rivera was arrested in the case. Catherine, whose the last name, chat, y'all help me every single time. Still cannot get it right. Catherine M. was arrested October 1st, 2016. October 4th, 2016, Rivera pled guilty to second-degree murder and was sentenced to 19 years in prison, concurrent with his 12-year sentence in a existing federal RICO case. Also, if somebody's got other cases out, they are going to dime you out in a fucking second. Oh, you want to know who hired us? Sure, let me tell you. Can I stay in federal prison, please? That's going to be the question. If you're Rivera, you're like, I'll plea, leave me in federal prison. Do not send me back to state custody. I want to be with the feds. Leave me there. Garcia was convicted during a joint trial with Catherine, October 2019. Catherine was retried and convicted in May 2022. Shortly before the second trial, Charlie Adelson was arrested April 21st, 2022. Charlie was convicted November 2023. 1 week after Charlie's, it's 1 week? No, Emily, stop. 1 week after Charlie's conviction, over 9 years after the homicide took the life of Dan Markel, Donna Adelson was arrested at Miami International Airport with a one-way ticket. The facts upon which the state of Florida indicted Adelson was indicated. No, the facts upon which the state of Florida indicted Adelson was indicted. It's not me. That's the sentence. Grammarly would have caught it. The facts are that Adelson made derogatory comments. This is the defense's perspective. So we're going to downplay. That's what's going to happen. Donna Adelson made derogatory comments about her son-in-law during the course of the divorce proceedings between her daughter and Dan Markel prior to the homicide. She spoke to both her son Charlie and her daughter Wendy the morning of the homicide. Law enforcement conducted a bump demanding money from Adelson after the homicide, which she did not pay, that she signed paychecks out of her son's business. He was a dental specialist. At his direction to Catherine after the homicide took place, and she attempted to vacation. I've heard the jail call. Vacation is not what she was attempting. She attempted to vacation in Vietnam, a country that does not extradite, more than 9 years after the homicide. More than 7 seconds after her son was convicted of conspiracy to commit murder. Incarceration issues, medical issues. Adelson is a 75-year-old female with the typical medical issues of aging, exacerbated, I can never pronounce that word properly, by the conditions of confinement. Yeah, confinement sucks. Hearing problems that are compounded due to a medical issue that cannot be addressed by medical personnel in the detention facility. This is more information than I needed to know, but okay. They're trying to, every defendant who has medical issues and private attorneys make this argument. Harvey Weinstein has made these arguments over and over again. Spectre made these arguments a million times. We've seen Diddy make medical arguments. Everyone would rather be in medical and in medical custody and in the medical bay than in general pop. But Donna had to go to an ENT every 3 to 4 months to have her extremely small ear canals cleaned out with proper equipment. Your Honor, my client has very small ears. Very small ear canal. They need to be cleaned properly, and general flushing of the ear canals will not work. Your Honor, she has small ear canals and they are goopy and she cannot hear us. Look, I get it. However, she also has severe pain from a pre-existing medical condition in her back and legs that cannot be relieved by the medical care available at the detention facility, and excruciating pain in her left shoulder, down her arm and into her hand, the result of an injury received during an attack by another inmate at the detention facility. We'll get to that. Within the past few months, Adelson began experiencing shortness of breath that has reached the level where others comment about hearing her struggle to breathe. Counsel has actually had difficulty hearing phone conversations with Adelson because her labored breathing is so bad that it interferes with phone reception. I don't think it interferes with phone reception, but it might interfere with you being able to hear because she's so loud, but okay. On a visit to the medical unit with other inmates on February 3rd, 2025, even the medical personnel asked what the loud breathing noise was, and the other inmates pointed to Miss Adelson. I'm sure they are sick of listening to her breathe loudly. Oddly enough, is it though? When Miss Adelson was having a medical visit with the doctor at the detention center prior to February 3rd, the doctor refused to even listen to her chest because that was not the reason you are here, and you will need to get another appointment with the physician assistant. There are rules. It is difficult. I am not surprised that the jail is like, you have an appointment for whatever it is, your toe. I'm not able to handle all of the things. We have literally 10 minutes to deal with the complaint. The problem is it's going to take months to get back into medical. I get the frustration, but also medical care in custody is not great. On Saturday, February 1st, in the early mornings, Adelson was in the bathroom area and accidentally bumped up against the washing machine and cut herself on the right arm of a rusted metal bar. She couldn't get a Band-Aid. The nurse told her to wrap it in toilet paper and fill out a form. They didn't have any forms. It took her a day to get the form. And finally, a sergeant brought a Band-Aid. And then she couldn't get to medical and she couldn't get the cut addressed. And then on Monday, she finally got to medical to have her wound cleaned and get a tetanus shot. Adelson needs medical care that cannot be obtained at the facility. If she remains incarcerated, the defense will need to prepare motions to seek permission for her to receive care outside of the detention center and obtain a court order for each appointment. Okay, get a court order for the appointments. Attorney-client privilege. It's impossible for Adelson to engage in attorney-client privilege communications via phone. This is what the court's going to say, though. So go to the jail. If you can't hear her over the phone, go to the jail. They have private attorney-client rooms. I imagine these attorneys are not in Tallahassee. But go to the jail. You chose to have a client not near where you live. Go to the jail. That's the option. Within the pod, more than 60 other inmates have the opportunity to listen to her side of the conversation. It is difficult at best for her attorneys to hear Adelson when she speaks due to the enormous amount of background noise caused by static, phone connection issues on the tablet, and noise from inmates in the background. Adelson has had to get onto her bed and cover her head with a blanket so she can hear counsel and counsel can hear her. On one recent occasion, when Adelson ended the phone call and pulled the covers off her head, there was a guard standing over her listening to the call, probably trying to figure out what the fuck she was doing. Do they not have bays? Like, they should have bays where you go to do your attorney calls. On one recent occasion when, so there was a guard standing there. Well, if she's under the covers, probably. Lack of sleep. This was one of the number one complaints that made defendants lose their mind in court. When court had to push court dates over, one of the biggest complaints for defendants was court days meant they were up at like 2 a.m. to get to court, and they weren't sometimes back to custody until after 10, and so they would miss meals. They would be very frustrated about coming back to repeated court appearances because it totally fucked up their day. Hannah said she has a cordless phone. She has a tablet to communicate with her attorneys. So lack of sleep. She is not happy with her sleep schedule. This schedule maintained for providing food and medication to the inmates at the detention center results in Adelson sleeping on average 2 hours each night, period. A typical day for Adelson is as follows. Nighttime medication distribution, 11:30 p.m. to 1 a.m. Sleep commences after inmates quiet down at 1:30 a.m. Awaken for breakfast at 3:30 a.m. I cannot imagine that they are awaking for breakfast on non-court days at 3:30 in the morning. Lie awake in the dark on the bed until lunch is served, and they seem to indicate that lunch is served at 9:30 a.m. Lie awake in the dark on the bed until lights on, and they say lights on are at 3:30 p.m. I imagine that there is a time missing and that lights on is at 9:30 a.m. and that lunch is at 3:30 p.m. Lie awake in the dark on bed. Possibly leave bed and walk around in circles for exercise depending on who the guard is. Dear diary, today, the guard I do not like was on duty. So I could not leave my bed to walk around in circles. Possibly leave bed and walk around in circles for exercise depending on who the guard is. This is just extraneous information. 6 p.m. Dinner served. There's a time missing in all of this, so the chart's off. Back in bunk until nighttime medication at 12 a.m. So there's a time missing in all of this, but whatevs. Physical abuse. And then they talk about the fact that she has been harassed in the showers by other inmates, that she was placed in a cell with a mattress on the floor where she had to lay without clothing for more than 50 days. There is not a chance that she was 100% naked for 50 days. There's just not a chance. That did not happen. Without a change of clothing, maybe. But no, she was not naked for 50 days. Adelson has been physically abused and threatened with abuse throughout her incarceration. I don't doubt that. She was assaulted in the shower. She wasn't pushed, but another inmate ran their hand up her spine while she was showering. That scared her, which probably made the other inmate laugh. Most recently, Adelson was standing in the area of and facing her bunk bed. Another inmate slammed into her from behind, knocking her into the frame of the bed, which was very painful. When she turned around and asked the other woman why she had done that, the inmate replied, "Because you're a fucking killer." Don't confront the other inmates. Donna, you are not the top bitch in any of this. Ma'am, some of that money from the plane ticket should have been spent on a prison consultant because you are not the top dog. I don't think people should be physically harmed. It is a reality of incarceration, and navigating that reality is not always easy. I don't know if Donna is good at navigating that reality and not pissing other people off. I would offer that impulse control in custody is not what you would see in the real world, and that when you are dealing with low impulse control, don't piss people off to the best of your ability. Oh yes, prison consultants are in fact a real thing. Prison consultants are 100% a real thing. Oh, I didn't mean to delete that comment. I'm sorry. I tried to highlight it. Apologies. I double clicked the button. There is such a thing as prison consultants. It is a real thing. It is generally people who have been to prison, to whom it was a rude awakening, and they help you navigate through it. Yes. I am sure that Martha Stewart hired a prison consultant before she went to federal prison to talk about what the ins and outs were. I am sure Teresa Giudice did. I am sure Jen Shaw did. Yes, especially when you are unfamiliar with how that might work. So, yes. This last bit doesn't surprise me. What's going to happen next surprises me none. The most severe and frightening incident to date, however, occurred several months ago and again was in the bathroom area of the pod. The bathrooms are always an issue. Based on the records obtained, the incident occurred on or shortly before October 7th, 2024. Adelson was bent over brushing her teeth with her right hand and leaning on the sink with her left hand. All of a sudden, she felt her left arm being jerked violently behind and up her back. She was yanked in that direction, and a much larger inmate told her that she knew Adelson got canteen and that from now on, she was going to get canteen for her too. The fact that she did not get face checked into the sink is probably a very good thing for her. However, if this inmate was going to forcibly get her to get canteen, maybe this was an inmate to make friends with. Maybe. So, her arm was grabbed, she was grabbed, and the inmate was like, I know you get canteen, you're getting me canteen too. You don't need to put money on my books, you need to buy me food. When Adelson tried to ask why she would do that, ma'am, can you imagine? Why are you doing that, bitch? You're getting canteen. I want some too. And I'm bigger than you are. That's why. Why would you do that? You are not talking it out with this inmate, Donna. When Miss Adelson tried to ask why she would do that, she was told by the large inmate that she was going to do it. Ma'am, why would you do that? Why wouldn't she, Donna? Miss Adelson was scared for her life and what more physical harm would come if she didn't comply. From that point forward, this aggressive inmate was instructed or has instructed Adelson that canteen packages she wanted ordered on a weekly basis. Yeah. That's how Murdaugh made friends in custody. Murdaugh knew, though. Murdaugh got all the extra canteen and started doling it out. I guarantee you Diddy's buying people canteen and putting money on people's books. 100%. There is a whole different system of how things work and how you make alliances. Donna should have been watching Survivor. Make alliances. Don't be like, why would you do that? Murdaugh started real early with that shit. Was like, Murdaugh was Harry Potter. Bought the entire trolley of sweets and was like, y'all want some? I got you. Where did Murdaugh's money come from? I have questions about. But that was his plan, and we've heard it on his jail calls. Why would you do that? So from that point forward, Adelson started buying canteen for the quote-unquote aggressive inmate because she was afraid for her life, and she told her husband to order the packages each week. She never told her husband why, and he just assumed. Do we know what the husband assumed? Did you talk to him? He just did it because she told him to. He assumed Adelson wanted the food for herself because the meals provided by Leon County Detention Center are disgusting. Okay. After Adelson receives her own canteen, purchases through the normal jail site, she also receives the 2 separate packages from the site ordered by her husband. She keeps the additional canteen items in the area of her bunk, and either the aggressive inmate comes in to get the items herself or sends someone else to get the items she wants. Make friends, not enemies. This particular incident caused terrible pain to Miss Adelson on the day of the incident and has continued to this day. She has requested medical treatment from the jail for the pain on numerous occasions, but has gotten no relief. It has caused excruciating pain in her left shoulder and shoots down her arm. Yeah, she probably needs an MRI. And even tingling in her fingers. She probably does. She probably needs an MRI. Since the court heard the original motion by initial counsel, some jail staff, including supervisors, continue to take actions which can only be intended to punish Miss Adelson. For example, inmates are provided with locked storage bins to store commissary and personal items. Miss Adelson has been allowed 2 additional bins for her legal materials. That sounds like they are accommodating her. On more than one occasion by different officers, Adelson's legal materials have been tossed out of her storage bin, resulting in hundreds of pages being tossed around or tossed about and left out of order. Guards have commented in the presence of other inmates at Adelson's perceived wealth, which led to additional requests by other inmates for Adelson's commissary. They searched your locked storage. They do that. Solitary confinement. Adelson has attempted to seek medical care for her pain, shortness of breath, and other health issues for several months, and her requests for appointments have been routinely denied or not properly addressed. However, on Monday, February 3rd, she was finally taken to the medical unit because of all of her issues, including the cut. And the physician assistant asked about the pain in her left shoulder and how it started. Adelson disclosed how she had been attacked by a fellow inmate. Thereafter, without the knowledge of Adelson, the medical unit reported the attack to jail personnel, as they do. Within a short period of time, 2 supervisors at the jail came into the annex and told Adelson to roll up her bed and get her bins because she was being removed from the pod. So she got attacked. She told them at medical she got attacked, and they went to move her. She's not going to like where they moved her to, but they went to move her. They explained Adelson had done nothing wrong and then took her into the room to question her about the attack. That seems incredibly reasonable because it sounds like she didn't report the attack earlier. And when it's reported, they're going to do something. Adelson was reluctant to disclose any information because she truly feels retaliation by the aggressor and or her affiliates within the jail. That's a concern, of which she has her affiliates in the jail, of which she has many that Adelson has already had to deal with. So whoever is asking her for the commissary has other inmates that are her circle. Moving Adelson out of that situation is reasonable. Adelson disclosed all the facts, including the extortion by the aggressor and how her husband unknowingly satisfied the demands by purchasing 2 extra packages of canteen each week. Note, from October 7th to present, Adelson has spent over $1,100 on separate canteen. The jail supervisors advised Adelson that it was their responsibility to protect her, and the only way they could do that was to put her in solitary. And that's the unfortunate side effect, is that if you are getting assaulted, they are going to move you where you can't get assaulted. But often the only place that you are unreachable is either in medical, sometimes, or solitary. And solitary sucks too. Since Monday, February 3rd, Adelson has been placed in a cell by herself. She's only allowed outside her cell Monday, Wednesday, Friday for 1 hour in the morning, and on Tuesday and Thursday for 30 minutes. When she is released, she has no contact with anyone else and can only use the time to shower, walk on the rec deck, or watch television. Other than that, she's on complete lockdown in a 6x9 room that has a bed, a toilet, and a sink. Note, the toilet is in full view of the window, and the door is approximately 4x30. That's not uncommon, by the way, that the toilets are in full view so that stuff can't happen. In most jails, the toilets are not private. Federal camp type jails, more so, but not, she is not in prison yet. She is in jail. So yes, they are visible. Everyone will see you go to the bathroom if they are in that area. If they told more people that, I think it would have a deterrent effect. Hey, if you have to go to custody, everyone's going to watch you poop. They say she has no risk of harm to the community. She probably isn't a risk of harm to the community. Flight risk is interesting. Adelson has no passport and has been placed on a no-fly list. That's interesting to know. And thus cannot schedule a flight bound for any domestic or foreign destination. Her husband is 80 and would relocate to live with Adelson in Tallahassee if released. Look, Adelson is not happy. I understand. She should not be attacked in custody. It is a very real circumstance in custody. It is an entirely different social structure. And when the lawyers are writing that she was, her arm was grabbed, this is far from the worst thing I've seen happen to people in custody. Her arm was grabbed and twisted behind her back. At her age, it might have torn her rotator cuff or done other damage to her. It might have been an issue. But her turning around and being like, why would you do that? Just indicates she has not really read the situation correctly and is not navigating the situation properly. So she wants to be out on bond. She wants to be out of custody. She wants to deal with her medical issues. She would pay to be on house arrest. She would pay to have monitoring. We all know from the Fat Albert case that monitoring doesn't always work. The problem is she was running. She was running. Let's talk about her running. I die at Emily's comments. Don't do crime unless you're ready to poop where people can see. It's a deterrent. The people who are like, jail is bad. They don't tell you the reality of it. Look, some people are like strip search, whatever, but we'll draw the line at pooping in public. We'll draw the line at pooping where people are watching you. It's a real deterrent. Custody sucks. They cannot keep you safe. And they try, but often being kept safe involves being in solitary, which also is not good. So, Adelson is being held at the Leon County Detention Center. And again, jail, different social environment than prison. Also tends to be a bit more physical depending on the detention center. But most detention centers, the hierarchy is not as well structured. So there tends to be a lot of fighting because the hierarchy is not as well structured. Adelson is being held at the Leon County Detention Center awaiting trial under conditions that will result in her inability to receive a fair trial and unable to adequately participate in preparation for her defense. Her health is failing. She is in constant pain. She cannot hear normal discussions, which is also going to make it difficult for her to adequately navigate the social circumstance if she cannot hear what is happening. And that puts her at risk too, which is another reason to put her in solitary, because she's at risk because she can't hear what's happening around her. Much less at any reduced level of speaking with counsel, at counsel table, at trial, when she is not receiving a fraction of the amount of sleep necessary to assist in her defense. At this point, Adelson is aware that the remainder of her time at the LCDC leading up to and during her trial, she will be in solitary without any access to interaction with other friendly inmates, art classes, or other human contact whatsoever, appointments with attorneys accepted. Yep. Her interaction should have ended up with the conclusion. Her incarceration should have ended upon the conclusion of her trial in September 2024. I mean, likely she would have gone to prison. Through no fault of her own, I take issue with that statement, her attorneys were removed from her case and her trial continued for a period of more than 9 months, thus extending her period of incarceration. She wanted the attorney she wanted. Proposed conditions of release: electronic monitoring. She will reside in Tallahassee pending the outcome of trial, comply with curfew, with the only exceptions being appointments with attorneys, court, and medical purposes. No travel outside Leon County, report to pretrial release, and other circumstances as deemed necessary. Let's look at her motion to suppress real quick, because the motion to suppress involves that phone call. The phone call with Charlie Adelson, where the jail call indicated that she was getting ready to run. That one, they want to suppress it. Let me pull this up real quick. Come on. Pull up in a separate window. There we go. Let's go ahead and switch which tab we're showing and then get back to that. That's the motion to suppress. Let's motion to suppress, and then we'll go to court, and then we'll go to questions. Alrighty. This is from February 7th as well. I should have swooped. I didn't. Defendant's motion to suppress. We're going to go through this a little bit more quickly. Defendant Donna Adelson, through her attorneys, would like to suppress some shit. I'm sorry. That was a summary. Would like to suppress portions of a telephone call, as they say below. On November 15th, 2023, Adelson was indicted for first-degree murder, conspiracy to commit first-degree murder, solicitation. One piece of evidence the state intends to use against Miss Adelson is a recording made after a jail call ended on November 7th. I don't know if the jail call ended. I don't know. The call was originally made by Adelson's son Charlie to Adelson while he was incarcerated in the LCDC. Although the call was dropped on the jail side of the call about 8 minutes into the call, the open line continued to record. Oh boy, did it ever. Did it ever. By this motion, Adelson requests the court suppress the recording after the jail side of the call terminated. When it says, "This call is being recorded," it means this call is being recorded. She didn't hang up the call. So it's still being recorded. Emily said, if the jail call ended, wouldn't it not record anymore? She left the line open. So the line was still open. You can hear it on that call that the line is still open. So it disconnected Charlie, but the line was still open. The state has the burden to establish expectation for warrantless inception of the terminated jail call. So the defense is arguing that this is, in fact, a warrantless, essentially wiretap. A warrantless search constitutes a prima facie showing. The thing is, there's no expectation of privacy. Chiquita Banana said she didn't think it ended. That's why she didn't hang up. Yeah, I think she thought Charlie was coming back because we could hear it. And she's having a full ass conversation with everybody in the house, waiting for him to come back on the line. That's what it seemed like to me as well. They're arguing it's a warrantless search. My argument on the other side of that would be, if I were making the argument, that there's no reasonable expectation of privacy in a recorded jail call because you're told it's recorded. And if you don't hang up the phone, anything on an open line can be recorded. Statement of relevant facts. We went through this on, it's actually fairly short and succinct. Well done, lawyers. November 6th, Adelson was convicted of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. He had been held without bond in the Leon County Detention Center since his arrest April 21st, 2022. On November 7th, he called his mother, Donna, from the jail. The recording of the call is 25 minutes and 29 seconds in length. At the beginning of the call, an automated voice notifies the recipient of the call that the call will be recorded and is not private. This call is being recorded. The recipient of the call is required to acknowledge that the call will be recorded prior to speaking. If you choose to accept this call, please press 1 on your keypad now. It's like a Zoom call. At 8 minutes and 5 seconds of the call, Adelson realizes that Charlie is no longer on the line. At that point, Adelson reasonably believed, that's argument, that the call had ended, and she puts the phone down. She's just like, we'll wait for him to come back. Because that doesn't say she hung up. Putting the phone down doesn't matter. She didn't hang up. She put the phone down. It's not, I can't reach my demonstrative phone. It's not like she put it down on the receiver. She believed the call had ended and puts the phone down. She did not hang it up. At the time of the call, Adelson was present in her home with her husband, attorney, and the attorney's husband. I didn't know who the other voices were on the call. It'll be fascinating to listen to this again. After Charlie's end of the call dropped, they continued speaking. Was it her attorney at the time? Oh, it doesn't say her attorney. It just says attorney. So not her attorney. It just says attorney. At the time of the call, no law enforcement agency had obtained a wiretap authorizing the interceptions of her calls. They didn't need one. It goes without saying that inmates have a diminished expectation of privacy, and aside from calls with attorneys, their calls can be recorded. The same is true for anyone who accepts a call from an inmate for the duration of the telephone call. Period. They are trying to argue that the duration of the call ended when Charlie was no longer speaking, not when the call hung up. This call was not intercepted. That line kind of concedes the point. The state legislature stated the purpose of Chapter 934 is to define the circumstances and conditions under which the interception of wire and oral communications may be authorized and prohibit the unauthorized use. We're not going to define oral communications and wire communications. I don't think this is intercepted. I don't think this is a wiretap. I don't think this is an end route around a wiretap. You didn't hang up the damn phone on a recorded jail call, period. You got to do what you got to do because that call's bad for her. Like, it's not good. I get it, but I don't think the argument's well taken. To determine whether a person had a reasonable expectation of privacy, which society is ready to recognize, courts look at the circumstances of the communication, including the manner in which the oral communication is made and the kind of communication, the location in which the conversation or communication occurs. First, she is in a room with 4 people, so it's not private. Second, she is on a recorded line that tells you it's recorded and not private. Third, she didn't hang up the phone. There is no expectation of privacy here. They're citing case law that say communications which take place in one's home are protected. This is an exception. Although Adelson consented to the telephone call being recorded when she received the call from her son, what was the scope of her consent? Stating that where a search is based on consent, the court must determine whether the search was conducted within the limits of the consent given. I would argue that the boundaries of the consent given are the length of that phone call. And if the phone call doesn't hang up, then you're still on the call. All right. They're going to cite other case law that I'm going to disagree with. So resuming, Adelson's conversation after, I wish they put the timestamp. That sentence is awkward. Adelson's conversation after in her home was an oral communication protected by Chapter 934 after her son was disconnected. Just Call Me Hen. I covered the call on the Emily Show. We'll link it down below. And then I will find a clean version of the call and link it too. It's online. The question here, that is an awkward title. The question here is whether the consent the recipient of the call gives for the call to be recorded terminates when the inmate side of the call ends. It terminates when the call ends. And if the call's not done, the call's not done. Typically, when 2 people are on the phone having a conversation where at least one of the parties is using a cellular phone and one end of the call drops, the call terminates. That's not always how that works. The line was still open. I don't know how Adelson was disconnected or if he just accidentally muted himself, but the line remained open. It did not click to terminate. And no, the call doesn't always terminate if one end terminates. Oftentimes you're sitting there going, wait, can you hear me now? Are you there? Am I not there? Are you not there? And then you hang up. You still have to hang it up. Unless your end drops. That's not how cell phones work. Footnote 1 says, in Title III jurisprudence, there is a concept referred to as off the hook. Please tell me what off the hook means. Please define to me the jurisprudence of off the hook. They mean leaving a phone off the hook. Like a phone that had a hook. For which specific authorization must be obtained. This isn't that either. This is a jail call. Emma Mack said, how did this even happen? If his end dropped, wouldn't that end the call anyway? How did this situation happen? I don't know what happened on his end of the line, but the line stayed open until Donna hung up. And it's a collect call. So I don't know how it stays open, but there's a lot of talky talk that happens. It sounded to me, and I listened to this a while ago, it sounded to me that they were waiting for Charlie to come back to the call, and they were talking, waiting for him to come back on the line. Like it had glitched and he'd be back. That was my perception. But I haven't listened to that call in a minute. Certainly one can consent to their communication being intercepted by accepting a call from an inmate. However, that consent must necessarily be limited to the consent to record the communication between the inmate caller and the one who consents to the wire communication. You consent through the end of the call. And when the call ends, the communication ends. The call didn't end. It's a novel argument. I don't think it's going to I don't think it's going to fly. Once the inmate side of the call ceases to function, the inmate is no longer on the call and the recipient of the call believes the call is over. And then they hang up. The recipient's consent for the call to be recorded must also terminate. There is no function for that. The only function for that is to terminate the call. They say that must be true unless law enforcement receives authorization pursuant to the wiretap statute, which was not done. Pursuant to the call, since the communication was unlawfully intercepted, it must be suppressed. Jacob said you can withdraw your consent by hanging up the call. Agreed. Agreed. Wouldn't you look at your phone and then go, oh, it dropped, and hang up? I think, here's what I think. It is my speculation that Charlie called her collect, so she was paying the collect call. There was a call initiation fee, and I think she was waiting for him to resume the line and be on the call so she didn't have to pay the initiation fee again, or the call initiation fee. That's my speculation, which is why she did not hang up. Aren't the calls timed? It's a collect call, so the money's going to keep ticking. But again, it's a reason to incentivize hanging up. You're being called. So that. So they are saying that from the time Charlie dropped the call, this should not have been intercepted and should be suppressed. I don't think it's going to fly. I think they had to make the argument. I don't think it's going to fly. We're going to go to court. We will take a look at what time we are done with court and see if we get to the call. But her putting the phone down and not hanging it up does not terminate the recorded call. I think she probably doesn't like that result, but the call is recorded till it's terminated. I don't think it's an en route wiretap when she has the ability to hang it up. We'll see what the court says before trial. I understand why they need to make the argument. I think they absolutely need to make the argument. I think the evidence is bad for her. So I think they very much would like that to not be the evidence. Let's go to court and then maybe we'll do the call again. It's what, 25 minutes? Less than 25 minutes. Let's go to court and see. We'll see how we're holding up. We'll see. Not y'all, me. We'll see how me's holding up. Me is still a bit under the weather. Let's go to court first. This is the Zoom hearing. This is the only portion of the Zoom hearing that's available. It's about 20 minutes long. We are going to see Donna asking again for the bond hearing with the court. So let us go to court. Let me make sure that's not going to echo. Let me make sure we have our live court. This is a hearing from yesterday, February 11th, 2025 in the afternoon. They are getting ready for trial. So I don't know what that is. All right. Let us go to court. Let me make sure the audio is gained up a little bit. Oh God, that's terrible. Such a Zoom court. Donna is not been transported from custody for this hearing. So we will see her on Zoom. Try with this audio real quick. That's a little better. It's gonna suck until they're in front of the cameras. All right. Hopefully that's a bit better. Let me pull that up. I know you guys could hear that. So all right. Let's go back to court for Donna Adelson asking for a bond hearing.
Yeah. It's only just
It is not clear at this point.
That's not my client, Judge. My case 2022 CF 336.
They're calling the case to order.
We actually went to FSU's Trojan Library yesterday, Judge. They're working on getting us some more documentation. We have filed a Brady demand. I think we have it set for a hearing, I believe. What's your...
How's the sound now for y'all? Do we need this up anymore? I know the sound is garbly. But do we need, I don't know if louder will actually help.
Court. So I would ask that we would set this for that same day of that hearing, Judge.
What's that name again?
DEAK.
That'll be 226,
There we go.
be heard at the same time as the motion.
That'd be fine, Judge.
Yeah, 226, Judge.
Yes,
they're finishing
motion
up another
hearings on
matter.
226.
The next one is James Rackley, 2024 CF 2477.
So they're doing
We are
calendar.
negotiating with the prosecutor, Mr. Fuchs, by the resolution. If we could have 30 days, Judge.
Just calendar stuff.
Mr. Fuchs, anything to add?
No, Your Honor, he's asking me to be more reasonable, and I asked for reasonable reasons to be more reasonable.
Yeah, we're working on more reasons, making more reasons. Time saving for you, Your Honor.
325 at 2:30.
Dominic Rondinelli, 2024 CF 2769. We're trying to get more reasonable again with Mr. Fuchs. And, but I think we're working on a resolution. 325, is that the next one, Judge?
That is 325 at 2:30.
They're just
The
doing
last one,
calendar
Judge, I'm
call.
covering for Mr. Davis is
Real quick,
2024
calendar
CF 3341. State by prosecutor, Mr. Fernandez is here. I think they want to set it for April, case manager.
Mr. Fernandez,
That's fine, Judge. We're just starting discovery right now. No objection.
415 at 2:30.
Thank you, Judge.
What's the name again?
Rajiv Shah, S-H-A-H, man.
Again, normal court, doing court things.
415 at 2:30.
Donna clearly did not watch Orange is the New Black.
Yeah, there's no room. There's no room.
They set the bond hearing.
That's right. Ms.
They
Adelson.
set the bond hearing in this hearing based on the minute order. But no, I did not watch the hearing. But based on the minute order, they set the bond hearing.
We want to send you a prompt to unmute
If it's off
on
the
your
record,
side.
if it's off the record, I have the date for it. So they do set a bond hearing.
Did you get the prompt? I see your lips moving, but we cannot hear you. One moment. I'll send it
I love this
again.
judge so much. Yay. Zoom calls are even better when it's Zoom from custody and someone else has to unmute her. It's just delightful. Mm-hmm. We're
He
gonna
gets,
zoom.
yes, he needs to get sub.
Okay.
All
Can you
right.
hear me, John?
I can hear you.
We can
clearly.
hear everybody.
Let's go ahead and address Donna Adelson, 2023 CF 3226.
Okay, case is called.
Zellman,
Good afternoon, Your Honor. Joshua Zeman on behalf of Ms. Adelson.
Counsel's in court.
Jackie Fulford on
I
behalf
don't think we're going to see counsel in court. We're just going to see Donna and Zoom. Counsel's in court.
of Ms. Adelson.
There are a couple of things that we wanted to address initially. The state had previously perpetuated the deposition testimony of Dr. Clark, the former medical examiner. That was done by prior defense counsel. We've reviewed the material. There was one portion at the end that we had requested that they edit out, but we would stipulate that would be appropriate to present to the jury during the trial in our case. We've spoken with Ms. Adelson about that as well. And even though we were not counsel at that, defense counsel didn't ask any questions, and that would have been our strategy as well.
very well. You may continue.
We are also stipulating to the foundation of the extraction of Wendy Adelson's cell phone that was conducted by Marsha Rodriguez, who will be out of the country at the time of the trial, so that they don't need to present her testimony in order to introduce the contents through other witnesses.
That's fair.
Um,
Foundation will be
We
stipulated.
did want to
too.
inquire with Your Honor about the status of the in-camera examination of prior investigator.
With that, Lynn, has a date already been set for the?
I don't think so. Did we didn't set a date yet.
I provided his cell phone number.
This would just be me meeting with him. It's not a
Okay,
motion.
Yeah, no,
Okay.
I'll follow up on that.
This judge is such a vibe. He's like,
We do have some issues with regard
Can we continue?
to discovery and prior case management. Your Honor had indicated that based on the conflict that existed in prior counsel, you would understand if we were going to redepose some of the witnesses that had previously been deposed by prior counsel. There are three
Well,
such.
hold on. I believe I said if you needed to raise the issue, you certainly could, but
We'd like to
do
raise the
not
issue.
accept that as a blank permission to redepose.
We didn't, Judge.
Okay, go ahead.
So we've been working to schedule depositions with the state, and for this morning, the
I love this judge. Don't get ahead of yourself. This is, I said, if needed. If needed does not mean yes and.
For the first time, we learned that they do object to us redeposing three of the state's witnesses. One would be Chris Corbett, the second would be Special Agent Patrick Sanford, and the third, Robert Adelson. Mr. Adelson is the son of Mrs. Adelson, of course. His deposition would not be lengthy, but we
The
do
other
need to
son.
redepose him. The depth of the conflict between Mr. Rashbaum representing Charlie Adelson and Donna Adelson is probably much deeper than the court understands. And to the extent you'd like to know further why we would like to depose these witnesses.
Oh. Oh boy. Oh boy. Counsel's just throwing prior counsel under the fucking bus. The conflict with prior counsel is probably deeper than the court understands. And this is the concern. Did prior counsel not pursue defenses for Donna because of their loyalty and conflict with Charlie? Or vice versa? Is Donna's best defense, Charlie did all this shit and asked me for stuff, and I'm just a loving mother? I'm batting my eyelashes. And I did not know what he was asking me for, so I just did what he said. Is that Donna's best defense? Probably. My son did all of this, and I was just trying to help. But the other lawyers can't make that argument. So the new lawyers are like, shit, we got a lot to deal with. Lauren, Charlie is on the state's witness list. Yep. Oh, she wanted those lawyers. She definitely wanted those lawyers. I wonder if she wanted those lawyers because it seems that she had those lawyers first. So did those lawyers also have loyalty to her before loyalty to Charlie? And did those lawyers not pursue Charlie's defense, which would be, I was just doing what my mom asked. I don't know what's going on with my sister. My mom asked for my help, and I just said, sure. Like, the best defense for both of these defendants is the other one did it. So, and with multiple defendants, that's really common. It wasn't me, it was them. But does having the lawyers that are loyal to her representing her son forestall that defense prior to her being arrested? Does it keep her from getting thrown out of the bus? So, interesting that they say the depth of the conflict is not fully known to the court. Oof.
Agent Patrick Sanford and the third, Robert Adelson. Mr. Adelson is the son of Mrs. Adelson, of course. His deposition would not be lengthy, but we do need to redepose him. The depth of the conflict between Mr. Rashbaum representing Charlie Adelson and Donna Adelson is probably much deeper than the court understands. And to the extent you'd like to know further why we would like to depose these witnesses and that particular conflict, we'd like to be heard ex parte and in camera.
No!
With Ms. Adelson present to provide some information to the court as well on some attorney-client privilege information.
We want to know.
All right, this is going to need to be memorial.
Counsel is correct. Counsel's correct. I want the tea. In camera just means in chambers, ex parte without the other side. Your Honor, this is attorney-client information, but we can explain to you what the fuck's happening. We can't explain to the prosecution what's happening. We can't explain to the public what's happening. We can tell you how bad this is. The tea.
Memorialized to the extent that
Just
you
like
can in the
write this shit
motion.
down.
As far as any hearing that would occur in camera, I will make a decision on that. But first, I actually need to read the basis of what you're seeking and why.
Now,
Thank you, Judge.
with respect to Ms. Corbett, Your Honor,
Make a
we haven't
request.
even received Sergeant Corbett's completed revised presentation. That is what the defense intends to take his deposition concerning. We've been told that we will have that presentation by this discovery cutoff, and so we were actually going to have to file a motion to extend the discovery cutoff for purposes of taking his deposition. And that
file
was
it yet?
tentatively scheduled for May 14th. Being that that would give us approximately 2 weeks to review the revised presentation. That's the reason for Mr. Corbett's. That's not a conflict issue, but we can certainly memorialize that in a written motion if that's what Your Honor would prefer.
I love that there's like
Just
abbreviations
going
within the
back
closed
and
captioning.
looking at the dates and the different cutoffs. 4:30 is the discovery cutoff by order right now. Ms. Dugan, as to providing Sergeant Corbett's presentation, why is this going to be so lengthy?
He's just working on the cases that are in front of him right now, but he has assured me that he's going to be working on this presentation as soon as he possibly can. I don't know of any new information in the presentation than what's already been given to him. It's more of formatting and making it look better as opposed to anything substantive.
Okay.
And my memory, if it serves me correctly, is that prior defense counsel's deposition of him was done after the same, as far as them getting the copy of what we were going to use, as far as everything substantive we were possibly going to use is in there. But, you know, the final result might look better at trial and be formatted in a different way. But substantively, it was all there. We certainly, and we want to be reasonable. We do object to, as far as all of these witnesses, they sent us about 24 hours they need to depose several witnesses. We worked with them to get times that we are available and will continue to do that. Some of the witnesses have never been deposed before. We obviously have no objection to that. Some of the witnesses have been deposed by prior counsel of other co-defendants. Looking at the rule 3.220, it says any cases, including ones with multiple co-defendants or even consolidated cases, no one should be deposed more than one time unless good cause is shown.
So what's a good
if
cause?
it's something that pertains to their client that's, new, we don't have any objection to that. But as far as just setting these people for hours and asking them a lot of the same information
you don't
that's
get another
already
bite
been said
the
in
apple.
prior depots, we would object to asked and answered and not want those people to have to be deposed again. And then as far as the folks that they named, I think it was
Not only have some of these witnesses been deposed, but a number of these witnesses have testified at multiple trials. So there's a lot of information out there. And Ned in the chat said, what is one of the most true things in court must be hard to sit there in silence? Yes, it is. Yes, it is. Right to remain silent and ability to do so are two different things. It's hard.
Agent Stanford and Corbett and Rob Adelson that Donna Adelson's former counsel has deposed. As the court said, we would ask that good cause be shown. We're fine with that being ex parte and in camera. But we would ask to have that done, be able to weigh in on that from our side as well in those same situations, and object to them being deposed again. If there is some new information in Corbett's presentation as of April 30th that they didn't know about before, we would absolutely be fine with him being deposed on that information,
information
but
only.
just not
That's reasonable.
having to go back through what's already been said with, hours and hours of depots and prior testimony.
If you heard typing, it's me.
All right. What I am not fine with is moving this trial date if it does not need to take place. April 30th is the discovery cutoff. We're going to leave that in place for now. Everyone is to work accordingly up to the deadline. If it has to be extended, it will.
I like
But
this
there's
approach.
still 2.5 months to that point, right?
Yes, sir.
We'll drop the motion, Judge.
Yes, sir. And, certainly, by way of a brief response, and I will be brief, the rule cited by the state contemplates that the co-defendants are all being tried at the same time or have all been arrested. It defies logic to believe that.
These trials have been spaced out. They are not co-defendants that are linked by one information.
Thank you very much, Your Honor. Lastly, this morning, I provided a proposed
Her
order
attorneys have already
to the
deposed
court from the August 30th and September 6th motions in limine. I prepared those.
Before we get into the motions in limine, I'm just going to note that what I appreciate about this judge is what we've seen a lot of judges do. He is not going to extend the deadline. He is going to say this deadline is firm. And then if there is an issue at the deadline, show me everything you did to get this done before the deadline, and then maybe we'll do it. It's like having a deadline on a homework assignment. Magically, it always gets done. You're like, I wish I had more time, but now hyperfocus will kick in and it'll get done when it gets done. If you keep extending the deadlines, things will just expand to the amount of time that you have. So the court is keeping the deadline, and when you get up against the deadline, we'll then give some exceptions if you were working diligently to try to keep them moving along quickly and towards the trial date.
Based on the transcripts that I have prepared of those hearings. I provided them to the state twice over the last month and have not gotten a final answer. Does Your Honor want me to submit the transcripts from those hearings?
You can do so. I'll review them. Ms. Dugan, as the proposed order, is the state objecting to it, or you don't have an opportunity to review it?
I did speak with Ms. Kaplan about that and we reviewed it. We don't have any objection.
Very well. I'll still review the transcripts to ensure it is accurate, but trust but verify. Go ahead.
Yes, sir. And
Trust but
there are
verify.
some additional motions to suppress and a handful of motions to limine. I'm hoping to
Eliminate.
get the motions to suppress filed in the next week to 10 days.
There's more?
So that those can be heard properly. The motions in limine, we're certainly going to try and get those filed early to mid-April, so we can get those heard as well. I just wanted to let the court know that the motion to suppress that we filed last week is not the only one that's coming.
There are more.
I believe the date that we were going to have for the pretrial motions that was going to take place on Friday, May 16th.
That's
Obviously,
what I
more
saw.
that can be heard prior to then will lessen the burden on that day, but anything that's still outstanding, that's the day it's going to be heard before we move into trial posture.
Yes, sir. Certainly with the scope and breadth of the
The
motions
judge
that
is
we
like, we're
are
not moving this shit
working
again.
on, we'll try and get those on your calendar much sooner. And lastly, I wanted to update the court on the expert that has been retained. I spoke with them for the motion for change of venue. I spoke with them yesterday, Mrs. Fulford and I did, and they are intending to provide us with the end product by the end of the first week of March. And as soon as we have that, we'll be providing that to the state and get that set.
I forgot
Provide
that was
that to the
pending.
court as well and get it set for a hearing.
All right. Concerning this report,
Right. With the motion
and
to change
I'll
venue.
leave this to your judgment, but do any of these matters need to be filed under seal to alleviate essentially the issue you're complaining of for the motion?
Yes, Your Honor.
Very well. Ms. Dugan, does the state have anything to raise?
I mean, the
today?
motion to change venue is going to be like, too many people know about this case. So,
Right. Upcoming through the deadlines, as we've spoken about before, the discovery deadline will be April 30th. We'll also have one last case management on March 25th at 2:30. As needed from there, we'll have different hearings on motions and we'll continue to
3:30.
move to June 3rd.
Thank you, Judge.
Thank you, Your Honor.
We are in recess.
oh, he didn't set the date. It was just in the Minute order.
Let's move on with calling the other matters
Thank you,
this
Chad.
afternoon.
Court's like, and we're done. That's it. She's going to be on screen for a minute, so we will leave it until they move on to their other cases. But they did set a date for the bond hearing, bail bond hearing. She will have a date for bail bond hearing to address whether or not she wants to get to that. She clearly wants to get out of custody. We will see what the judge has to say. I think flight risk.
That concludes the appearance for Mrs. Adelson.
Flight risk is going to be one of the bigger
finished.
parts.
Have a good afternoon.
Thank you, you too.
She's finished. Next.
Mr. Zellman, go ahead.
I've just received a from Brett Brown.
All right. They're moving on to other cases. And that is it for the status hearing. Donna Adelson would like to be out on bail. The court, I'm going to need to pull back up the docket. The court set a date for that bail hearing, so we're going to keep an eye on that. They also set the date for the pretrial motions in May, further case management in March. I imagine we'll see the motions in limine in April. We will probably see the motions to suppress argued in end of March or April. And we will see what the court does. A lot of defendants complain about their health issues in custody. Sometimes those are true. Sometimes those are exaggerated. Sometimes it's a combination of the both. The custody arrangement seems to have said, look, if you're getting attacked by other prisoners and causing injury, then we need to keep you away from other prisoners, which also seems to be an unsatisfactory result for Donna Adelson. There really isn't a good option there for her other than, well, either you're by yourself or you're not by yourself. So we will be checking back in on Donna later this month and see what the court does with the bond hearing. The state has not responded yet. I imagine what the state will say is she's a flight risk, and she's a flight risk, and she's a flight risk. Charlie Adelson stayed in with no bail until his trial. I imagine based on these charges alone that Donna Adelson can stay in custody, though her age, the fact that, like with Charlie, his parents both being out can create a problem if they try to help him escape. Her age will fall into that factoring. The judge might just order that she be allowed to seek outside medical treatment and facilitate that with the jail, which is not easy to do, or leave her out on house arrest with nothing but medical appointments and at home. So we'll see what happens with the court, but the flight risk is a real concern here, even though they say she's on the no-fly list. I don't know if they will be able to prove that, if that has been verified by the government or not, that she's on the no-fly list. We will see. Donna is not faring well in custody. That doesn't surprise me. But it is an unpleasant thing. It's not surprising to me that she was trying to find a one-way ticket to a country that doesn't extradite because she knew she was going to be arrested and was trying to get out of the country before that happened. That's going to factor heavily into the court's decision here. You knew you were getting arrested. And you tried to get the fuck out of town. The state is going to use that to show that consciousness of guilt. She was fleeing. The defense is going to try to argue that that's not consciousness of guilt. She just was taking a vacation. We'll see. But that call is going to matter, and it will be interesting to see. All right. What do I think will happen? I don't know what this court does on bail. Based on Charlie, it seems more likely that she stays in custody, and that wouldn't surprise me. I think he'll try to accommodate some of the medical as best he can. Some of the medical won't be accommodated. Some of it will. It's not easy to do. So let's get to the very end. Miguelina, I can summarize everything we covered real quick, and then we'll do questions. So Donna Adelson has a motion to suppress pending, more to come, a number of motions in limine to come, and the motion for bail or bond, which will be argued at the end of February. She is arguing that she should be allowed out of custody, not only to deal with medical issues, but because she is not a flight risk, that she's been put on the no-fly list, that she doesn't have a passport, that she's 75, that her husband's 80, and that they are happy with her being on house arrest. She's also moving to suppress that jail call, which precipitated her arrest at Miami International Airport, saying that when the Charlie part of that jail call, when he dropped out, that the line remaining open is essentially a unauthorized and illegal wiretap of the call. I imagine when we see the state arguing the other side of that, the argument's going to be this jail call is being recorded and she never hung up the call. So the call is recorded until it hangs up. So if Charlie's speaking on the call or not, her leaving the line open means it's still going to be recorded. And lots was caught in that line being left open. And I have linked the podcast where I went over that jail call and what was said in it down below, because I have already covered that a couple years ago. So if you want to go watch that, that is being listed. So Donna Adelson is not happy with her custodial arrangement. The judge is very firm that this trial is going forward at the beginning of June. And it's going to go forward at the beginning of June. It'll probably take them 4 or 5 days to pick a jury and then maybe 2 weeks of trial. So we will see this trial going forward through the month of June. About mid-June, I will keep you in the loop. I don't know if the Corey Richins trial will be done by then. So we've got spring trials stacking up as the courts are getting busy. This one will be an interesting one. I don't know if there will be any other arrests in this case. It seems that the state has kind of gone group by group. It was the gunman and the associate who was the middleman, and then Charlie, and then Donna. I don't know if her husband will be arrested. Wendy has some type of immunity deal, so we will see her testify yet again. It's going to be an interesting one, so stay tuned for that. Let's get to questions. Let's get to questions. Let's get to questions, shall we? We shall. You've got questions. I've got questions. We got questions. All right. All of the Lawnard questions. Good to see you. Good to see you. I don't know what is going on with Wendy Adelson. I need to go back and do a little bit more research on the immunity. It's a limited immunity, but I need to go back and look because I don't know the full scope of that, but I will go back and look. I don't know if Wendy can be arrested. Anna's asking the real questions. I talked about this yesterday on Instagram and on stream. Hold on. We need to look real quick. I don't know if anything has happened today. For a quick road so far. Oh, why is my typing not typing? That's weird. For a quick road so far, yesterday I was mentioning that Duo the Owl was getting way sassy after the Super Bowl. And their social media team was just on one. And then all of a sudden, like, Duo was dead. What? It was wild. So let's take a look and see if anything happened today. Now we're on watch because it seems like the mystery of the internet that we need to solve. Duo has implicated strongly a Canadian rapper. The last thing I saw on the other Bird app was, let's see if we can find it, was the Duo saying, hey Drake, or say Drake, and then all of a sudden Duo disappeared. So let's take a look real quick. For all of you like, what in the world is popping off? You know I love a sassy social media team, and this one is turning into true crime. It really is. Here's what shocked me yesterday that we have not talked about yet. Here's what shocked me yesterday. First of all, we've got Duo. Oh, hold on. Let me make sure I can play sound through this without it echoing. Give me 1 second. I did not do that correctly so that I can play sound. So, first of all, during the Super Bowl, they posted, translate this sentence, pass the ball to your own team, WTF number 15. What in the world? What in the world? During the Super Bowl. Then Then we get to them teaching music. No, I'm not trying to heart the post. I'm not trying to heart the post. I am trying to get to the other post. This is the post I was trying to get to. Then they post this at the end of the Super Bowl show. Hold on.
Trying to strike a chord, and it's probably A minor.
Yep. Now they're teaching music. They're not just teaching languages. They're not just like on my son's Spanish streak. They are just coming for everybody. So, however, this is duobolical is hilarious. It literally just ended. The social team, every social team wishes they could be. This social team is unhinged on another level. It's amazing and I love it. Like I love their social media team. It's that's not what I need on my Instagram feed. I'm trying to laugh about a cartoon owl for a language app. What I don't need is Diddy's face on my feed. But of course, all the time. We need to go to this other post. That was user error. Because the fact that this is the post, that the post is Drake after attending his own funeral on national television. What the hell? What is Duolingo doing? First of all, the BBL jokes. Second of all, that comes on the heels. Like there's lore to this because of course there is. There's like origin stories to this. But this was the post. Glad I'm not the only owl with a BBL on this list. Glad I'm not the only owl with a BBL on this list. Duolingo, what are you doing? What are you doing? What are you doing? What are you doing? However, it's shady and funny. So this is tied back to the other one based on music, right? Just absolutely wild. So then we get back to the Drake reference. What? So then we get back to the Drake BBL reference with the shade. Then we get to yesterday. We were talking about the fact that Duolingo was ripping on the Super Bowl, which is what I thought was funny. That the bird mascot for the language learning app was shading Drake by saying we teach music now and singing A minor. Then yesterday, Duo died. And then we get all the RIPs. I'm not putting the music up because we're going to look at some of these. But then Duo died, they say, and they're just like carrying the bird mascot out to the truck before the official announcement. And all of the other apps, all of the other social media managers are like, today's our day. Today's our day. Baskin Robbins, only the good birds die young. Tarte Cosmetics, RIP Duo Big Back Lingo. That's the song that's playing. What is happening? What is happening with the social media accounts? Hold on. I want to see what Scrub Daddy said, but the internet doesn't want to internet. There we go. Why does the Scrub Daddy social media team trigger warning before open casket next time? Scrub Daddy, what is happening? What is happening? So yes, for all of you, like, what is happening? The fictitious mascot of an app has died. And all of the other social media accounts are on it. Spirit Halloween getting our takeover banner ready. Spirit, What? Come on. Also, where's Chick-fil-A saying eat more chicken? Emily, it's too dark. Stop it. Girl, no. Then they post an official announcement yesterday. I posted all of this on Insta. So if you don't have Insta, I'm sorry. I posted this on Instagram yesterday. I'm going to try to make navigating Insta and oh my God, it's got 1.3 million likes. Of course it does. Navigating Insta and trying to get myself out of the way is not easy. Okay. It is with heavy hearts that we inform you that Duo, formerly known as the Duolingo Owl, is dead. Authorities are currently investigating his cause of death, and we are cooperating fully. TBH, he probably died waiting for you to do your lesson, but what do we know? So they're just going to call out the internet. We are aware he had many enemies, but we kindly ask that you refrain from sharing why you hate him in the comments. And I can't move this out of the way. I'm sorry. If you feel inclined to share, please also include your credit card number so we can automatically sign you up for Duolingo Max in his memory. We appreciate you respecting Dua Lipa's privacy at this time. Because Duolingo, it seems, had a one-sided relationship with Dua Lipa that Dua Lipa did not participate in. So Duolingo is also respecting the privacy of Dua Lipa at this time. Pop-Tarts says, Mama, a legacy behind you. Lucas Arnold. Duo, I will find who did this to you. Chase. Actually, folks, please do not comment your credit card number. I responded to that one and said, Chase, finally a message approved by legal, because no one else's legal team was working. Duncan, and if you do not get the deep lore of this, I apologize, because no, I need to not view the replies. Can we close the replies? No. How do we close them? I can't social. Gosh darn it. We need to get to the replies from Dunkin' Donuts. Because Dunkin' Donuts said, first it was Spidey, and now this, when will it end? However, it was my understanding that Spidey D was not dead. When we left Spidey D on stream on Duncan's account, Spidey D just got their password taken away. There is lore on top of lore. On top of lore. Also, I did not see this last night when I went to bed, that Dua Lipa came back into the comments. I can't believe Spidey D I'm Carrie Boss. I'm not accusing Spidey D of murder. I think Duncan murdered Spidey D. Because Duo announces that Duo's dead, and Duncan comes in with, first it was Spidey and now this. I think Duncan is saying that Spidey D is dead. WTF, Duncan? That's not what happened to Spidey D. I also commented on that. Because I don't think Spidey D was dead when we left Spidey D on Duncan's account. Kellogg's, bird to bird, we're going to miss you. Drink Arizona said pour one out for Duo. Drink Arizona, stop it. You know that's not meant by tea. Sunny D, why does Sunny D need to be in the conversation? Why? Because they do. It's 2025. It's like 2025 is Rapunzel, but instead of letting her hair down, she's letting us all down. Sunny D, what is happening? Spidey D might be involved here. I'm not sure. JetBlue said on our birthday. Way to make it about you, JetBlue. Why is Adobe UK having feelings? RIP Duo will give you wings in Illustrator. What? The social media, not Grindr. Grindr! Oh my God. Grinder. No more streaks. Time to hit the streets. Fair enough, Grinder. Fair play, Grinder. Fair play, Grinder. Oh, and it goes on and on and on. However, there is a comment where Duolingo responds, and it is not pulling up. It pulled up on my phone, where Duolingo responds saying, we are investigating a Canadian rapper. I put that up on my Instagram stories. Let me see if I can find it real quick. Because Duolingo had commented. Oh, wait, there's a new post. Hold on. We're going to finish the new post. Duolingo had commented that they were investigating a Canadian rapper, which I thought was hilarious because their last tweet was "Say Drake," which is also my stories. What started all of this? I have no idea. Kel, I have no idea what started all of this. I have no fucking clue. They just popped off about the Super Bowl and then Duo was dead. Update. Officials have identified the cause of death. More details to follow. Thank you for holding space for Duolingo. And then Dua Lipa, Till Death Duo Part. Breaking news. Update regarding Duo's death. More details to follow. Oh, Old Smoky Whiskey. First he haunts us about lessons. Now he's haunting our hearts. Old Smoky could say pour one out. Pour one out. I would take it better. It would be better taken than Arizona tea for me, but I love Old Smoky. Grinder's back. This death has the girls in shambles. Squashmallows. We will avenge you. American Heart Association. Proof that ghosting your lessons is bad for your heart. What is happening? Scrub Daddy's back. I won't rest until I have answers. Okay, Scrub Daddy, calm down. Scrub Daddy's in all of these comments all the time. Scrub Daddy was all over the comments with Duncan. Cheez-Its wants to know who did this. Cheez-Its is not resting until there's answers. At least Cheez-It snacks are delicious. I actually have some sitting on my desk for after stream. So yeah, Utz was not going to be outdone by Cheez-Its. I hope the suspense doesn't kill me too. Utz, at least you have pretzels. We got snacky snacks. Let's see what the next post is. So today things have popped off more. Wait. There's video? I didn't even put a trigger warning up. There's video? And a Cybertruck. All right, trigger warning, chat. Trigger warning. Apparently, there's footage of the crime. Hold on, I'm putting the sound on. We're going to have to watch this. We're going to have to run this back. Good Lord. I'm going to start this back from the beginning, chat. Don't worry, we will. Yes, they actually changed the icon. They changed the icon for Duolingo to the owl with the crosses on his eyes. Okay. Warning. Some of the following images may be disturbing for or to some owls. Hit by a car? He's a bird. Okay. First of all, the fact that they used the video in the background without paying the rights and still have it watermarked is hilarious. Like, what is happening? What is happening? Are they insinuating Duo went to hell? What's happening? There is background music buried in there. I can barely hear it. Do you guys hear it? There is background music buried under it. I can't tell what it is. Who is that? Who is that music at the bottom? There's music at the bottom under it. And I can't tell if it's Kendrick or Drake. Update. Reward for whoever can identify the driver. Please post any leads on TikTok. Oh, so now we're all going to play along on TikTok. The way they're going to drive engagement. Do you see a driver in that picture? It's driving itself, obviously. Pop-Tarts, new side quest. Scrub Daddy. Oh my God, not the Cybertruck. I'm going to be sick. Why? Because it's so ugly. NYX Cosmetics. I've never seen a BBL fly so high. Leave the... Good Lord. The BB... Hilton Hotels, is that you? Crying in our hotel room. Chevy, safety features matter. I'm not mad. I'm not mad. I'm not mad at Chevy being shady. I'm not mad. I'm not mad. Pinterest. All of a sudden we're detectives. Oh, Pinterest, where have you been? Every case we're all detectives. I don't know that song. The internet will figure it out. It's not going to be me. Let's see if there's any other brands that had things to say. I'm sure there are lots of them. So Drake driving a Cybertruck. Original Funko. The truck has been following me for a while. I keep seeing it everywhere. Run, Funko, run. So the mystery is going to continue, but they are going to drive all of their platform engagement to another platform. So that is what's going to happen. They are going to continue this on TikTok, which doesn't surprise me. But the other brands commenting are always hilarious. Yeah. Birds of a feather mourn together. Thank you, Bird. I think Grinder. Sorry, I was on my way to Trade's house. Grinder. Oh my God, Squashmallow knocked the legs right off a duo. Horrible. Squashmallow. Who? I tell you guys, social media managers are having the most fun with somebody else's social media campaign. It's just Fiverr. Duo dying by Cybertruck was not on my 2025 bingo card. Thank you, Fiverr. Thank you, Ego USA. Did you try to resuscitate? The comment section's not letting it go because Drake will be blamed. Thank you. Skylar said the underlying song is Humbled by Kendrick. It's not, we're not going to be done with this. I'm invested. I don't know about all of y'all, but I'm invested. So if you want to check my Instagram stories, I have Attorney Live. Who do we need to sue? Apparently Cybertruck. Tesla would be the answer. So whatever is happening on social is A, hilarious, and B, kind of shady. But I posted in my stories the vague and well, no, not vague references. The all of the things regarding to Drake because it's funny. So the fact that this social media account has taken all of its energy to just throw shade, which is what they do, is hilarious. So the owl has all the feelings. And yeah, it might be Rosetta. I mean, I don't know. The questions that need to be answered are many. But I do need to call us back. Hold on. Wait, there's stories. Oh, the stories are just the same post. Fair enough. And yeah, both of those posts. I went back to Duncan's page yesterday. They did not say Spidey D was dead. So Duncan being like, Spidey D died. Stop it. Stop it. Stop it, Duncan. Look, Steven, Grindr is just putting all the business out here in the comment section. Grindr is just here for it. Look, it's where we're at. Grindr's just putting it out there. Just all of the things. It's wild. Absolutely wild. So I think at the end of the day, they're going to be, well, continuing to shade a certain Canadian rapper who they accuse of having a BBL. There's more lore on Scrub Daddy's page. How are these brands connected? Okay, let me go look real quick. Is Scrub Daddy trying to clean the crime scene? I mean, they are really good sponges. Truth. Oh my God. The social media managers are nuts. The social media I'm scared. Did they run away together? Wait, did they fake their death? Did Duo fake their death? Did Duo fake their death to blame it on Drake? I will always love you. I'm just going to take a moment to say thank you again to our sponsor, because with all this music, we're absolutely going to get demonetized. So if there was ever a day to do this, today was the day, fam. Today was the day. Today was the day. What? 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 What I didn't need was a bird mascot and a sponge mascot having a live birth on the internet. Not even a midwife? Where's a doula? People! Where? What? What? I'll let go of a prayer for you. Does Dua Lipa know? Does Dua Lipa know? Does Dua Lipa know? I will always love you. What is happening? What? This. How long till those sponge owls are in Target? Give me a time frame. I saw the chat asking, how did we get into this rabbit hole? I fell into it after the Super Bowl because they were doing the A minor joke. That's how I fell down this rabbit hole. I'll let go of a prayer. They're 100% selling those sponges. Oh my God. Okay. Well, that's unhinged. Scrub Daddy, please respect my family's privacy during this difficult time. Scrub Daddy, does Dua Lipa know? Because we have questions. We have questions. Oh my God, did Duo die in childbirth? I mean, it should. Five Below really didn't like that bird, but we can babysit the kids. Five Below. Why you gotta be shady? This post was 5 hours ago. Jeez. Do all of these social media managers work in the same building? We're here to support you, Daddy. Now that Duo's gone, we're not the step parent, but we can be the parent that stepped up. Really? To the squish, squash, squish, mallows? Really? Squish, squish? Cheez It, thinking of you and your family. Cheez It, at least bring snacks. At least bring snacks. Tarte Cosmetics, what do you need to say? Duo said you were separated. I'm going to be sick. Tarte Cosmetics, get the fuck out of the comment section. What is happening? What is happening? Duo said you were separated. Oh my God. I don't know what Honeygrow is, but Honeygrow said Duo's legacy will live on with every dish we scrub. Nyx Cosmetics said, I can't begin to imagine how hard this is for you. American Eagle, I'm sorry for your loss. We're here for you. We're here for you, Scrub Daddy. Teletubbies? Teletubbies? With the AO? Teletubbies. Teletubbies was shady as shit up in Duncan's comments too. Teletubbies. The fuck is happening? Oh my God. Food court might start getting replaced with sassy social media court because y'all, where's Aldi, by the way? I have not seen Aldi's like, I'm staying by myself. I'm staying in myself. I don't even know where to begin with that. This is the most wild shit. And I'm living for all the other brands that are just like, I'm here for it. And the fact that everyone's now playing along. I'm just ready. I'm just ready. But I was not ready for the sponge birth on the internet. So there we are. Full circle. Yeah, I think that Duolingo needs to be sued by Drake in French. Duolingo gets sued by Drake in French for insinuating A, BBL, B, murder. Just for sure, Drake sues for emotional distress. For sure. For sure. Emily, the baby made Scrub Daddy and Duo a trio. Motion to name the baby trio. Music to my soul, motion granted. If they release these damn spudges, I'm buying one. Thank you, chat, for the fact that there is more lore on the Scrub Daddy page. What the fuck, Scrub Daddy? What the fuck, Scrub Daddy? What is happening on social media? I have not been paying nearly enough attention to what the brand accounts are doing. God damn it. I have been paying way too much attention to other people's lawsuits, but clearly I need to be paying more attention to what the social media managers are doing. God damn. They're like, I will full-throatedly clean that spoon for you. I got you. I got you. I got you. Oh my God. I don't know, man. I don't know how we got here. Yeah, I don't know how we got here. I don't know. I don't know how we ended up here. These were probably also the Super Bowl. Okay, well, Scrub Daddy is an Eagles fan. I'm here for it. So Scrub Daddy was Eagles fan. Got it. And then where did we go from there? How am I supposed to find a Scrub Baddie without my mustache? Pringles, please help. Excuse me, Scrub Daddy? Are you stepping out on Duo? Now, how do you feel? We have questions. Did everybody know that you guys were open or what? Were you on a break? Tarte Cosmetics seems to think you were on a break. We just have questions. We just have questions. How am I supposed to find a Scrub Baddie without my mustache? Pringles, please help. Pop-Tarts USA, mine's gone too, bestie. Pringles, I think I saw it over New Orleans. Goodyear Blimp, I saw it flying around up here somewhere. Cheez-Its, did you find it? Liberty Mutual, no. At least you still look good in yellow. Liberty Mutual, what is happening? What is happening? I don't know whose account this is. We can talk about mustache, but does it come with a scrub pussy? Come on. What? There are times when the social media teams just bring joy. And the more unhinged, the more hilarious. I will tell you guys, because there's no way she's going to get to this point in the stream, that when I talked about Duncan, my mother called me after that episode and was like, Emily, why in the world would a donut social media account do all of this? And I'm like, Mom, you're going to have to ask Griffin, because all of it has just gone very Gen Z, and it's so fucking funny. Brands are like, we're not going to be serious. It's going to be funny. It's going to be unhinged, and we're going to be here for it. I was like, I don't understand their donuts. I'm like, Mom, I get it. But also it's funny. So because it's funny. Scrub Daddy, just working on my diabolical smile. Oh. Do you say Drake though? What music is playing? Do we have music?
Fully defro, say Drake. I hate George. Fully defro, say Drake.
Fully demonetized.
I hate George. Fully defro, say Drake.
But worth it. Thanks, Incogni. The smile. They were ready for the Super Bowl. They were ready. He looked right at the camera. Eyebrows on fleek. Wow, Scrub Daddy. This GIF is amazing. The media teams are having the most fun ever. So I don't know who runs all of these media accounts, but they are having the best time. They are having the best time in the entire world. And the comment section is right along with them. The comment section is here for it. They're like, yes, Scrub Daddy. Yes, please. Oh my God. Oh my God. Oh, maybe Scrub Daddy is framing Drake. Maybe. But the social media teams were ready for the moments from the Super Bowl, and Kendrick Lamar's smile was the fucking moment. Still the moment. Still not over the memes. Still happy about it. Everybody's ready. Okay. Kate said Drake disses Kendrick and ends up with Scrub Daddy dissing Drake. Yeah. Duolingo said POV Drake watching his funeral on TV. Sure. It's 10 out of 10. It's 10 out of 10. I'm not mad at it. We're going to get to a few more questions. How did we end up down this rabbit hole? A minor. And then it went from there. And I was giggling at the internet yesterday before I watched Deal or No Deal Island because I didn't feel well. And I was like, this is fucking hilarious. And when the social media teams have a moment, I am here for the moment. I think it is funny. I really do. The fact that everybody is just like, you know what we're going to do? We're jumping in on Not Like Us. We're in. We're in. We are in. And all of the social media accounts being in the comments is hilarious. Also, the Scrub Daddies are pretty freaking great. So, also, will Duolingo get sued for defamation? It was really court related. In the most loose sense of the word, you can say it's court related. It's just ridiculous. But I love the social media accounts being silly. I really do. I think it's funny. It started with Food Court with Spidey D. And then when I saw that Duncan was insinuating that Spidey D had in fact been murdered, I feel like we've all been left out of the loop, and I am mad. I am mad. Don't do that to our Spidey D. So to all of our new members, welcome. To everyone who gifted memberships, thank you. I am seeing so many gifted memberships. For all of you that are members, don't forget to check your member spaces tomorrow. There's information up there today, and there will be information and early access tomorrow. For those of you that are in the Lawnerd app, in the Lawnerd Lounge, you guys already see that today, so thank you. For everyone else who's like, Emily, what is happening? New merch. Yes, Valentine's Day. Friday, we will have new merch. The shop will be open. I will keep you in the loop with posting about it. The shop will be Apple storing before this launch to make sure that nothing has broken, because the Lawnerds do break stuff every launch. So we will have a period where the store will be down, getting ready for the public launch and making sure that all of the orders that came in our pre-order are populated out. So we will be launching Friday for the public on sale. You'll get all that information. You will get all of the app notifications and the rest of it. So don't worry, Friday. But for those of you that are members here on the YouTube channel, you will get that information tomorrow morning. And for those of you that are in the Lawnerd Lounge, you already have that information. Chris K said, thank you, Emily, for covering the TikTok psychic still. Oh yeah, we don't let go. We're like a freaking terrier. We don't let go. I'll never let go, Jack, but we actually mean it. We don't like just turn around and let go. we're following it to the end. And so many cases, and there are cases that we've covered at the beginning and then not followed through, or they settle or what have you. But some of these cases we will check in on maybe every couple of months because I want to know what happens when they end. And the headlines hit and then all of it is gone. Like you see the big headline and then 3-4 years later, it's never resolved. But I think when we talk about how lawyers strategize in high profile cases, covering what happens in these cases in reality helps understand why lawyers strategize the way that they do. When I talk about, sometimes to my displeasure, the way that lawyers make some filings more for the public than for court, much more for the public than for court, it's part of a strategy. And it is not a legal strategy. It is a survival strategy. And when you see how long these cases take, I understand why. It's not always my preferred methodology, but I understand why. The lawyers are like, if we lose early in the court of public opinion, no one's even going to be here when this case resolves. So right or wrong, no one's going to know 3 years from now how this actually turns out. In a lot of high profile cases, that's true. It's more true in cases of intense local or regional interest than it is for like celebrity cases. Celebrity cases, generally people will come back around on, but we haven't talked about the Girardi case. And the last time I did, people are like, I'm over it. Like I'm done. He hasn't been sentenced yet. So we still have these cases that take 4 or 5 years to resolve and nobody knows what happens at the end. I'm Kelly and I grow it. Coming to Nashville next week. Emily need eggs. You're incredibly kind. We have a great farmer's market here, so we have been able to stay in the loop with eggs, but thank you. We live amongst the farmland, which is very, very helpful. So thank you. Botanist Gaming, you asked a question a lot of people asked in the chat. Can the TikTok psychic catch a criminal charge? Not unless something criminal happens, but not for this. And there were no, from any information we have, no police reports made. This was all civil. I didn't see any direct harassment, and a lot of the harassment laws don't account for somebody defaming you on the internet. That it doesn't, most of the laws accommodate for more direct interaction than that. And that's why defamation is the right route, even though a difficult route. Virginia, thank you for the gift of memberships. Everyone who gifted memberships and everyone who got memberships, you guys will have access tomorrow to the Law Nerd Shop. So do not worry. Thank you. I appreciate it. EDB with the 3D chess and fuck around and find out. I am patient. My memory is long and I do not drag other people into my bullshit. So, so yes. Stizit asked earlier, have you seen T-Pain react to the halftime show? Yes. So good. T-Pain streaming is hilarious. T-Pain's an amazing singer, but T-Pain streaming is hilarious. I love it. Katie said, so handing them a tablet with Coco Melon isn't a solution. No, not a solution. Not a solution. Rebecca May said, happy hump day, girly pop. This TikTok case is absolute rage fuel. Yep. It is. Because it just reminds us that there's not a lot we can do. There's some times where the shit's already out of the horse and there's not a lot you can do. And it's frustrating. It's also why I really try when we look at the early stages of cases. I didn't do it with this one at all. This case came through and I was like, this is bullshit. But with the early stages of cases, I very much try to be like, if these allegations are true, then the law might go this way. But there's always another side of the story, and then there's always the middle. And so I really try to say, we need to wait to see how this shakes out, because immediate decision makes it very hard to undo that down the road. And trying to keep an open mind as legal filings come in. I know how much we don't know at the beginning stages of a case. With the TikTok psychic case, I didn't care. It was so clear what was being said and so far out of left field. I looked at what was being said. I'm like, that's bullshit. When we go through other cases where it's like, there are going to be two sides to this thing and we need to see it sort out, I really do try to say, I want to see how this sorts out and try not to form opinions too early. And in some cases I do. And I tell you when I do. So so it's great. Boston Terror said your talk on internet bullying and trolls should be clipped. It's an excellent way to tell people how to step back and reassess. Look, I grew up in very different time, but back in my day, God damn it, Emily. I found then when stuff was an in-person problem, my preferred was to de-escalate and be like, if you have a problem with me, don't engage with me. I'm not in your shit. Get out of my shit. I'm not in your face. Get out of my face. I don't understand why this needs to be a problem. I'm not doing anything to you. So I'm sorry that my existence annoys you, but get out of my face. We're not doing that. I don't understand why it needs to be different on the internet with, hey, if this is not for you, keep it moving. I think there's room to have conversation about what's going on in these cases, what people are doing. I don't understand trying to run people off the internet. And I do think that those that most desperately seek attention on the internet will go away when ignored. I think there is a way to just ice that out and just be like, I am not giving this attention. Nope, I'm not giving it attention. There are cases that I will not be covering that I've been asked for because of who they are centered around right now, and I am not covering it. So it's just not. And I'm not going to. I'm not giving people attention. There are other cases I will. But it's frustrating. And I really don't understand the need to perpetuate it. It's like, okay, just go do you. It'll be fine. Lexi said, glad to be here for the fuck around and find out of all things today. Today was definitely a find out day. I think Donna's going to have a find out as well. I'm interested to see how her trial shakes out and see what all the conversations are. We know so much from the Charlie Adelson trial that we know what her actions were. If you're paying people in a murder for hire, it's going to be real hard to argue that you weren't paying them for the murder for hire. Like it's going to be hard. So Casey Cat asked, will the TikToker have to go to jail before she actually stops? I hope that this has been a wake-up call and that this has been deeply uncomfortable and that this will be a reset. But this is going to affect both parties going forward, and that's the hard thing. From my perspective, everything we've seen in the court filings, the professor did literally nothing except exist and have a job. And this world of shit was hurled at her from the internet. And now she is having to deal with lawyers in a lawsuit because it was never going to go away. And at some point, you are stuck. And that's really frustrating. Really, really frustrating. So we will see. And that frustrates me about this too. Will the TikTok ban be an issue for discovery? In the TikTok psychic case, discovery is already done. So no, because discovery is done and the liability phase of the case is done. So Angie, I have seen these rumors too, that Diddy is not getting along with fellow inmates and is jealous of Luigi. I can see that. I can see that happening. It can't be easy to be a high profile person in custody. And it's very much not going to be easy with the allegations that Diddy is facing. The allegations Diddy is facing are not going to go well for him. Luigi's in a different situation. The Slay Files, thank you for the gifted memberships. Caroline said, okay, Donna, I did 90 days in county. While all of this sucks, it is just the way it is. It's a steep learning curve, but you got to read the room. Yes. Mm-hmm. It's not easy. And county is tough. Tougher than prison. County is tougher than what federal prison is like. Liz asked this earlier about, and I saved it, it was about the in-camera hearing. Will that ever become public? Unlikely, because it deals with attorney-client privilege. So it's very unlikely. Christine asked, why do we do depositions? They are called different things in different jurisdictions when we are dealing with criminal cases. Sometimes they are just witness interviews. Like California does not do formal depositions in criminal cases. They do witness interviews. Formal depositions, you sit down and ask the witness questions. It's essentially a witness interview, but often under oath with a court reporter. And it is a witness interview. You are allowed to interview the witnesses of the other side. What the prosecution was saying is, hey, we are just about done with this. And you've already gotten to ask those questions, so we're not going to do it again. Chat and producer Megalina mentioned that Duo is still posting. Look, there are some post storms that I'm not here for, but this is not one of them. We'll check the last post, and then we're going to say goodbye. Oh my goodness. The social media managers are just done. I love it. I love it. And then I'm going to get going because it is 3:00 and I need to bounce. What is this? You killed it literally. Total XP. Great blazing. Bring Duo back to life. Claim XP. What? February challenge, Duo's dead. Bring Duo back to life. Help pay for Duo's coffin. Learn how Duo died. They're just like, go play in the app. Go play in the app. Duo has a family to support, apparently. Is it the greatest marketing campaign ever? It might be one of them. It's better than any of the Super Bowl ads, I gotta be honest. Learn how Duo died. Extend your streak as a tribute. Duolingo's like, do you volunteer as tribute? We heard from the authorities the best way to channel your grief and unlock more about the investigation is to do your lesson. Together, if we really try, we can bring Duo back. It's not a bad marketing campaign. I'm not mad. I Love Pie says, I thought Emily didn't do breaking news. It's an investigation we're deeply invested in. We are deeply invested in this investigation. I'm here for the marketing plan. Duo's dead. Is he going to join the Black Parade? Yes. Yes. Duo, I can save you. Duolingo, we were supposed to get married. Duolingo seems to be spoken for. Did Drake kill you? The fact that Drake is catching smoke in all of this is hilarious to me. The other social accounts aren't even on this yet. I can't wait to see what Pringles has to say later today, because you know they will. Cheez-Its is going to be right up there being like, in multiple languages. Well, if y'all are on Duolingo, you're going to have to go do your lessons. It's just so funny. I love that Duolingo took the Super Bowl into a full marketing campaign. I'm sure it was planned in part, but I love that they linked it together. So with all of it, Law Nerds, it's been great to see you. Thank you. Anne said, clap for Tinkerbell vibes, but fun. It really is. It really is. I will see you guys tomorrow. I'm going to put up a post in the member space to see what we're covering. I am hoping that my throat will feel a little bit better tomorrow. And mods, I promise we'll do shorter streams. I promise. All right. Y'all, drop in the chat what language you're learning on Duolingo if you are or are not, and if you want to be, because everybody's now in for it. I will see you guys tomorrow. Thank you for joining me in court today. I know it was a long one. I appreciate you. It's good to see you. We got through 2 cases today. We'll probably only get 1 tomorrow, but that's all right. Law Nerds, you're the best. And a huge thank you again to our sponsor, Incogni, because we are definitely getting demonetized. And when we have sponsors and support of the Law Nerds, we can do things like fuck around and find out on Instagram to see what the social media shade is of the day and figure out what the marketing teams are doing, because they are hilarious. Law Nerds, you're the best. I'll see you tomorrow. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.